attention, please. Welcome to the Constitutional Court. We are about to start. Please make sure that you switch off your cell phone, please. Please ensure that your cell phone is off. Thank you.
Thank you, Mr. Chengo. Thank you, Mr. Bossman. Thank you, Mr. Marcus. Thank you, Mr. Kass. Thank you, Mr. Skakani.
Justices, I I am here for the IFP with my learned friends Jonathan Jones and Vera Sam.
Thank you too, Mr. Kemp. Thank you, Mr. Tokota. Mr. Tringle, I assume there is no waiver. Is it a fair assessment?
No, I think I should, because I am going to deal at the outset with what I think is the most important part of the case.
Yes.
And for that reason would welcome the court's questions.
Oh, from the word-go?
Indeed.
Thank you.
I propose to address four main topics. The first is the law, and on that score, the IEC's position on four issues of law. I will secondly deal with this court's judgment in Kum's case, its ratio and its implications. In the third place, with the electoral court's judgment in this case, submit that it was wrong on the core issue, and I may tell you that on this score my learned friend Mr. Marcus will deal with a subsidiary aspect of that judgment. And I will deal in the fourth place with the alternative application for direct access and alternative relief. On this score too, I will address merely the relief sought by the IEC, and I won't deal with the other proposals made by the other parties, because my learned friend Mr. Sekekani will address that in his address, and my learned friend Ms. Blizzard will deal with it in reply if needs be. So I start with the first chapter on the issues of law. And for that purpose, we have prepared a brief statement of the IEC's position on four aspects of law. I have distributed amongst my learned friends, and I wonder if I might hand it up to the court. It doesn't constitute submissions, it is merely the bottom line, the conclusion on each of four issues of law. If I might be given leave to hand it up to the court and then speak to it. There's one for the judges and for the clerk.
You may proceed in the meantime, Mr. Tringle.
The first proposition of law is this. It is that we accept that the IEC may only register voters in the voting districts in which they are ordinarily resident. And for that purpose, the IEC must obtain from the voter seeking registration the voter's address, if she has one, or the voters, enough particulars of the voter's ordinary place of residence to determine in which voting district it falls. The IEC is not required to verify that information, but it is the IEC's duty, once having obtained that information, to ensure that the voter is registered in the voting district in which her ordinary place of residence falls.
While you are there, did you say we may interrupt or not interrupt?
No, certainly, Chief Justice.
All right. What then would be available for a person who is not convinced that the determination that certain voters belong to a particular district is correct? What would that South African have to look at to satisfy himself or herself that the conclusion arrived at by the IEC is the correct one?
Chief Justice?
I'm not saying what the IEC does is wrong. I'm just saying, in the event of a challenge, what are we going to compare what to what?
Well, we submit that anybody who challenges the role would have to show that the voter is not resident in the district in which they are, for which they are registered. There is a second issue that you raised, Chief Justice, and that's this. what record must the IEC keep of the address of the voter? And I think that that is what you are interested in.
Not because the law requires it, but just to play it safe.
Indeed.
Yeah.
That is indeed the issue that we address. That's the second point of law that we address in our note. If I may refer to it, we say that the question is, must the IEC record the address? In other words, keep it and record it in its system. We say the following. Firstly, Section 8.1 requires the IEC to make the requisite entries in the voter's roll. Regulation 10 says that the entries that must be made are only the ID number, the name and ID number of the voter. Therefore, the IEC was not required by law to record the addresses of the voters at least until December 2003, when Sections 16.3 and 16.4 were introduced. When they were introduced, they didn't say that the IEC must now keep addresses, but we accept that it probably implies that the IEC must henceforth keep those addresses.
I interrupt again. Does it imply or does it require of the IEC to do that? I ask the question because Section 16, subsection 3 provides for political parties, and I assume by extension independent candidates, it may be a subject matter of debate, to have access to a national voters' roll that has in it physical addresses. How then would that be possible if it were open to the IEC to choose not to reflect the physical addresses?
We approach this case on the basis that Section 16.3, in other words, the section to which you refer, does imply that it should keep and record those addresses. So that 16.3 and 4 introduced that requirement by implication, but it only did so in December 2003. As at that date, there was already 18 million voters on the voters' roll. And that's really where the heart of this case lies.
Well, that's interesting. Here's another difficulty. What if from 2003 that was not done? What are we to do then? And are you in a position to say from 2003, in other words, after Section 16, subsection 3 were passed, that was done? And if it wasn't, what should be the implications of that?
And my understanding of the evidence is that it was generally done, but the evidence is ambivalent in the erudition with which it was done. It was certainly not done as a rule until December 2003. It was generally done from December 2003, because you'll remember that at the time that this case arose, there were no longer 18 million voters without addresses. There were 16 million voters without addresses. In other words, all the new or most of the new registrations and even some of the old registrations brought that number down from 18 to 16. But I can't assure you that it was fastidiously done from December 2003.
Are you in a position to say what percentage of registrations that took place ever since the amendment kicked into operation were compliant, so to speak?
I don't think so, Chief Justice. But frankly, that is simply because the case against the IEC has never been one that said that you have failed in your duty since 2003. The case against the IEC has consistently been, and I'm getting to it now, but has consistently been that what you were required to do was not only henceforth to record addresses, but to go back to the 18 million and find and record their addresses. And that's really where the dispute between us lies. The essence of the case against the IEC is that it should have gone back and found the addresses of the 18 million, or at least those of them who have addresses. That is the case, and you will see in the electoral court, in this particular case, the heart of the cause of action against the IEC was that there were 4,000 people on the roll without addresses. And the case made against the IEC was there ought not to be people on the roll without addresses, because you ought to have gone out and found addresses for them.
Well, that I understand, Mr. Trengove, except for one thing. If it was the IEC's position that the proposition that we should have gone further, in other words, covered the period before 2003, is incorrect. The correct position, according to our understanding, is that we were only under some implied obligation, or whichever way the IEC chose to put it, to reflect the addresses after 2003. Ought not the IEC then to have said, in line with our understanding, or the understanding of our mandate, this is what we have done to comply since 2003, or with the advent of the CAM decision?
Yes. Chief Justice, may I come back to that issue in greater detail when I deal with the electoral court's judgment in this case? Because that, with respect, was not the basis on which the cause of action against the IEC was formulated, or the case was developed. The case against the IEC was there are 4,000 names on the roll without addresses. And that means those people are illegally on the roll, because you ought to have found addresses for all of them. So the question was not, the attack against the IEC did not make that distinction between before December 2003 and after 2003. It was a general proposition that nobody ought to be on the roll without an address.
Are you sure we shouldn't give you 10 minutes just to make your case before we interrupt you? You still maintain that position?
Maybe what I should do is just take you through the propositions of law.
I think so.
Mr. Trengove, on the exchange that you've been having with the Chief Justice.
He wants to take us through the...
oh, okay.
Yes.
I'm interested in the table, if you can also have regard to the table that appears at page 421 of the record.
Just to manage it, Mr. Trengove, just do what you were minded to do, and signify when you're comfortable that we may interrupt.
Chief Justice.
Thank you.
As you see from this note of ours, the first proposition is that we accept that the IEC has always been obliged on registration to make sure that the voter's address or description of their place of residence falls within the voting district in which they are registered. And with respect, the IEC says, and there is no serious challenge to that evidence, that it has, as a general rule, always fulfilled that duty. That evidence is quoted in our heads from page 8 in paragraphs 21 and 22. So it is uncontroversial that the IEC was always under a duty to make sure that an applicant for registration is registered in the right voting district. About that issue, there is no debate. And there is no serious challenge to its evidence that it has always complied with that duty. There have, of course, been mistakes and there have been lapses. But as a general policy, it has always complied with that duty. The second question that we address is, was it obliged then to record that address? And that is where there is a difference between the parties, because we submit, for the reasons we set out in our paragraph 2, that there was no duty on the IEC to keep those addresses on record after registration has occurred. If there is such a duty, then it is one that was introduced by implication by section 16.3 in December 2003. And we're going to argue the case on the assumption that 16.3 did introduce such a requirement, but only did so in December 2003. And then, of course, the COM judgment in this case, of this court, recognized that duty, and in paragraph 5C, explicitly requires the IEC now to keep addresses. But I emphasize that paragraph 5C makes it quite clear, firstly, that it is a prospective duty imposed on the IEC, only from the date of judgment, that's from the 30th of November last year, and the duty imposed on it is a duty to keep the address on registration. In other words, it is quite inconsistent with the case made for the respondents that section 16.3 imposed a duty not only to keep addresses on registration, but imposed a duty on the IEC to go back to find the addresses of the 18 million already on the roll in December 2003. So that is as far as the duty to keep those addresses. And we emphasize that neither section 16.3 nor this court's judgment in COM, nor paragraph 5C of COM, said or implied that there is a duty to go back and find addresses for voters already on the roll. There is simply no such legal obligation imposed on the IEC. And that is why we say in our paragraph 3 of our note that the absence of a voter's address on the roll does not imply or even suggest that the voter's registration is invalid. And that is, there are two categories of voter on the roll without addresses, but perfectly validly registered. The one category is people registered before December 2003 because their addresses weren't kept and put on the roll, and despite the fact that their registration was valid. The second category would be those registered since December 2003 who don't have addresses, who were registered on the basis of a description of their place of residence, but who do not have a convenient address that you can put into the roll. So that the mere fact that there are names on the roll without addresses does not imply or even suggest that their original registration was in some way irregular or flawed. And that is the case against the IEC, that there were 4,000 names on the roll without addresses and therefore the roll is defective. We submit that there is a flaw in that reasoning because a name on the roll without an address does not imply irregular registration. And the most vivid illustration of it is that two of the independents, that's the second respondent, Ms. Tlokwe, and the third respondent, Mr. Tlokwe, they are two examples of exactly what we're talking about. People who were lawfully registered before the IEC kept record of the addresses, but to this day are on the roll without addresses. And when that point was made in the founding affidavit, if I may just give you the reference, but the reference is at page 405 in paragraph 43.4. But the interesting part is the response to it, which you'll find at page 556 in paragraph 78.5, where the answer is filed on behalf of the respondents. And in response to this statement in the founding affidavit that two of the independents are examples of people who are lawfully registered but don't have addresses on the roll, the response is in paragraph 78.5, I further submit that the second and third respondents will confirm in their supporting affidavits that, 1, they have been residing at their current addresses for many years. 2, they have supplied their addresses to the Commission when they registered. 3, the addresses are street addresses that are perfectly verifiable. 4, their addresses do not fall without the category of places in rural areas where verification of addresses is not possible. 5, that both of them have a cell phone and a bank account. 6, that by virtue of the above, their names will appear on various national databases. And then 6 again, I therefore categorically deny that the only means of correcting the voters' roll would have been an exercise of simply removing voters, etc. So what they said is that we accept those people who are perfectly validly registered, but their addresses aren't there. But the case made against the IEC is that you had a duty to go out and find addresses of people of that kind. And then the argument they make here is to say, I was perfectly contactable. I had a cell phone, I had a bank account. Your duty to find the addresses of 18 million people included a duty to find me, and you could and should have found us. Well, that's a different...
Mr. Trengo, may I just ask if you're going to deal with Mr. Marcus's argument on behalf of the ANC, that part of the COM order applied because of the apparent shenanigans in relation to the Tlokwe by-elections, and therefore that there was a duty at least to find addresses of voters in the by-elections who didn't have addresses?
Yes, in the heart of the COM case was proven, accepted, irregular registration of 1,040 voters, 25% of the registration since 2000. So that the COM order must be understood to be in the first place an order about 1,040 proven irregular registrations. And so on that score we accept that interpretation, but precisely because that case was concerned not merely with names without addresses, but concerned about proven irregularity.
Just let me know if it's time to interrupt you. I was just allowing you to round up before we could put questions to you.
Well, can I deal with the last issue of law, which is the fourth issue, and that is, we've now said the IEC were initially not required to keep the addresses, became required to do so since 2003, but there was no duty to go back to find the addresses of people already on the roll. There is then the fourth and last question, and that is it obliged to include those addresses in the voters' roll made available to the public, the political parties, and the independent candidates? And with respect, there are 3 sets of provisions which deal with that issue. And we deal with them in our paragraph 4, because the 3 sets of provisions deal with 3 different occasions on which voters' rolls are made public, and the rules that govern them differ. There is firstly section 16(1) and 2. They require the IEC to make the ongoing voters' roll available to anybody at any time on request, either for inspection or a copy at the prescribed price. So that is concerned simply with the ongoing voters' roll, which is made available to anybody at any time on request. And we submit with respect that that voters' roll is one that does not include any addresses, because it contrasts with 3 and 4, which does provide for the inclusion of addresses in the voters' roll. 16(3) and 4 operate at the time of national or provincial elections. And what they say, they were the provisions introduced in December 2003, what they say is that at a time of national or provincial elections, the voters' roll must be made available to the political parties, including the addresses of the voters. But it then, at the same time, because it specifies that on this occasion addresses of voters must be included, it introduces safeguards of the privacy of the people whose addresses are now made public. It says that this voters' roll may only be made available to political parties contesting the election, and those political parties may only use the voters' roll for the purposes of the election. And it reinforces that limitation by a serious criminal sanction, so that it is clear that when Parliament decided on this occasion and for this purpose to make addresses available to outsiders, it is confined to this particular occasion to political parties for purposes of fighting the election, subject to a privacy restriction.
Are you ready to be interrupted?
Indeed.
Or do you still want to be protected
I'm just
from
about
us?
there. I'm just about there, Justice.
You're about ready. Let me just go back to the point that the Chief Justice raised with you quite early. From December 2003, did the IEC have a duty to record voters' addresses?
We accept that they did, yes. Let me say, the duty, if there was one, is implied by 16.3, and it is not open and shut and clear that it does imply
implied?
such a duty. But
The section tells us that you provide political parties with addresses,
we're available, yes.
which means you have to keep them so that you can supply them.
We accept that there
You
is,
accept that?
there is an implied duty to keep the address.
So aside from us in COM, Parliament tells all of us that the IEC must keep addresses of voters in the voters' roll and make these available to political parties. It's a clear duty that Parliament sets, not us.
Indeed. That's the effect of 16.3 and 4.
Let's go somewhere else to your note. In 4.3 of the note you gave us this morning, the note suggests that Section 6.2b of the Municipal Electoral Act envisages a voter's roll without addresses.
Yes.
What is the justification for that proposition?
Well, we make the same submission, Deputy Chief Justice, about 16.1 and 2 on the one hand, that's in our paragraph 4.1, and about 6.2b of the Municipal Act on the other, simply because none of them say, well, let me first say, they predate December 2003, so that they existed at a time when there were no addresses kept, or no duty to keep addresses.
But we know that the definition of voter's roll in the Local Government Municipal Electoral Act means the national common voters roll. So we have the duty introduced in December 2003, and the municipal electoral law tells us that talks about a roll, and 6.2b in particular makes such segments available for inspection. And also 1 says the segments of the existing roll, but we know we have a definition of roll. It refers to the normal national roll.
No, with respect, we don't have a definition of the national voters' roll. The Section 8.1 of the Electoral Act says that the entries made, that the requisite entries must be made on the voters' roll. That's all we know.
Referring to the definition of voters' roll in the Municipal Electoral Act.
Yes.
It tells us it's the same roll as the national roll, common voters' roll.
Yes.
And we know now that we're talking about the same roll,
Yes.
whether for local or provincial or national elections. Does the duty in 16.3 then extend to municipal elections?
Yeah, well, there's a misunderstanding between us, Deputy Chief Justice.
Yes.
The misunderstanding is this. I accept entirely that elections at both levels of government, or all 3 levels of government, are conducted on the same voters' roll. The question is, what does that voters' roll include? It certainly did not include addresses before December 2003. And
okay, let's debate that also. Why not?
Well,
the law says that you will determine where a voter lives.
yes.
And IEC tells us we have determined that without fail, but we did not always keep the records. Why? Why not?
Well, firstly because there is nothing that had required the IEC to keep the addresses and put them in the roll. And the two provisions which do speak to the content of the roll.
So once they determine the addresses, what do? Do they destroy them?
They kept them, but in the course of time, a lot of them had gone missing. And they also make the point that very often the addresses on those forms were inadequate, so that when the voter came with inadequate information, they would sit down with an electoral officer who would question them and by question and answer determine where they lived, and on that basis registered them. So the records were both, some of them were inadequate and a lot of them went lost.
And the Chief Justice asked you after the amendment, did the IEC in December 2003 keep the record of the addresses?
Yes, it did. I can't tell you that it did so fastidiously and carefully because there was no great emphasis on it and the issue isn't squarely addressed in the papers.
And does that include descriptions of where voters lived?
I don't understand that it ever included in the roll the narrative of descriptions of where voters lived. No.
No, but when they inquire where a voter lives, the voter would sometimes provide a description.
Yes.
Otherwise, the IEC official will never be able to satisfy herself.
Always provided a description if they didn't have an address. And that is beyond doubt. They always got that information.
Yes. Now the question is, was there a recordal of that description after 2003? We've agreed already the duty exists, the statutory duty put up by Parliament. So the question is,
No. There was a duty to record addresses. If people didn't have an address, there's no duty to record the narrative that placed them within a voting district.
Then you must give address a very narrow meaning, isn't it?
Well, I
to go past that one.
I submit with respect that address is a description, an identifier of a place of residence, not a narrative which says between the two spaza shops under the water tower.
In the Kham case, what were we confronted with? How was it possible to have false registrations?
Justice, Deputy
because
Chief
there is
Justice,
the mischief that the judgment sought to get at. How was that possible?
Can I perhaps just complete my answer to your earlier question? There was always, and there still is, a description of the voter's roll, because Section 8.1 says that the electoral IEC must record the, quote, requisite particulars in the voter's roll. And Regulation 10 has always said that the particulars that must be recorded are the names and ID numbers of the voters. So the starting point is that a voter's roll is a list of names and ID numbers, not addresses. The first time that it was suggested that addresses must also be included is under Sections 16.3 and 4. But they don't say you must disclose the voter's roll. They say you must disclose the voter's roll, including the addresses. And then they add to that a restriction to make sure that those addresses are not abused. It would be wholly inconsistent with that parliamentary scheme of 16.3 and 4 to read 16.1 and 2 as meaning that addresses have always been included in the voter's roll and have always been accessible to anybody on request without the restrictions imposed by 16.1 and 2. So the status quo, at least when 16.1 and 2 was introduced, was that the roll is freely available to anybody at any time, but it does not include addresses. 16.3 and 4, for the first time, required disclosure of both of a roll with the addresses, but subject to severe restriction. You asked me about the CUM case. The CUM case, indeed, Deputy Chief Justice, was a case about irregular registrations. it was proven, and the IEC investigated and accepted, that 1,040 people had been irregularly registered. And there was never a proper explanation given for that lapse. So, and that was really what COM was about.
And if the law as set up in 2003 had been followed, would there have been room for false registrations?
No, but it had nothing to do with the law of 2003. It is common cause that the IEC has always been required to ensure that people are registered in the correct voting districts. And that had nothing to do with the law of 2003. That requirement was a requirement there from the outset and was not followed in those 1,040 cases. So that it is true that there was a lapse in COM. That was the subject of this court's censure in COM. But it was an aberration and not the normal practice that was followed. And an admitted aberration.
Mr. Trengove, I ask questions for you. And maybe before you go any further, and maybe also just to caution your colleagues, I hope nobody is going to suggest that any of the players, list of all the court is trying to disenfranchise 12 million people.
Indeed.
I've seen that in the heads of argument coming up, because that will call for some real answers if anybody comes up with that.
Yes.
I'm just cautioning that whoever comes up with that argument must be prepared to answer. This is what I need to understand. Let us assume that this court's judgment in COM was wrong. But it's there, it stands. What is it that the court required of the IEC to do in relation to the national voters' roll as it affects Tlokwe, for a conclusion to be arrived at that now we have a national voters' roll that complies with the court order? How far back did COM require of the IEC to go in terms of ensuring that the addresses are reflected?
You know, with the greatest of respect, the COM order itself said in 5C that the IEC must henceforth keep the addresses on registration. And let me just read 5C because it makes it clear, doubly clear, that that it is concerned with the future, not the past. It says, it is declared that when registering a voter to vote in a particular voting district after the date of this order, the Electoral Commission is obliged to obtain sufficient particularity of the voter's address to enable it to ensure that the voter is at the time of registration ordinarily resident, etc. And then D followed from that, that the roll must be made available at the time of municipal elections. But the part of 5C that I wish to emphasize is this, is that it says, it speaks about a duty at registration, at the time of registration, not a duty to go back and find addresses of people who are already registered. So it was confined to a duty to do something on registration.
Yes.
And that duty is imposed with effect from the date of the order. That's with effect from the 30th.
Let's take it in stages. Did COM make new law or simply restate the law as it existed at the time?
5C certainly did.
Did we change anything and come up with anything new in relation to the law that governs the registration of voters?
Not the law that governs registration, no.
So it was restated.
It was restating the law. We have, as you know, Chief Justice, we have some reservation about 5D.
We'll get to that.
But
yes.
That's got nothing to do with the process of registration.
Right.
That's got to do with the form of the roll made available to people contesting elections.
So on your understanding of 5C, does it have any impact on the voters' roll that affects Tlokwe, that cost the applicants to approach the court in the first place? In other words, does the order in COM 5C, order 5C, require of the IEC to do anything in order to correct the national voters' roll as it affects Tlokwe, or did the court merely give direction in relation to what is to be done going forward?
We submit with the greatest of respect that what you're talking about is paragraph 5C, and 5C says you must from now on get those particulars when you register voters. It said nothing, not only is it silent on the past, but it is inconsistent with 5C to suggest that there is a duty to go back and find addresses of people who have already been lawfully registered. 5C just doesn't make sense if there were a duty of the kind that the respondents contend for.
Which part of the order addresses the concerns that caused people to approach the court in the first place, if any?
All right. I mean, what the court did in COM was to set aside an election already held because the roll on which it was held was admitted to be flawed. That was the guts of COM. But as far as the orders going forward are concerned, it did not suggest that the flaws in the roll had to be cured by going back and finding addresses for the 18 million who were already on the roll in December 2003.
And what on the IEC's understanding of the COM judgment, I'm sorry, I'm not too clear with the pronunciation, I don't mean any harm. What, according to the IEC's understanding of the COM judgment, was required to be done to remedy the complaint that caused the independents to approach the court in the first place?
Well, the primary duty was to address the 1,040 irregularly registered voters. And the IEC explained that it did subsequently investigate all of those cases, and it removed those which were ultimately indefensible. 700 odd of them were removed from the roll. Not because they didn't have addresses, but because they were found to have been irregularly registered in the wrong voting district.
And what about the addresses? What was the understanding in relation to ensuring that addresses are reflected going forward?
Going forward, the only understanding is paragraph 5C, which says you must record them on registration. In other words, henceforth, make sure that you keep the addresses when people register. It didn't address, and it said, and in 5D it said that those addresses must be made available where available, must be disclosed where available. What the court didn't address is the 18 million who are still on the roll without addresses. That was not what COM was about. That was the issue in the electoral court, but not in COM.
I think I must reserve my other questions so that I don't monopolize the questioning.
May I go?
Mr. Trengo.
Before you move away from the Chief Justice's interaction with you, why is your case at all that the COM judgment disenfranchised 15 or 18 million people?
No.
That is not your case, is it? Why are we dealing with that at all?
The electoral court, because that was the effect of the electoral court judgment, but not COM judgment. No. The electoral court misunderstood COM. But it certainly suggests that any...
Show me the part in the electoral court judgment which deals with the historic
Chief Justice, I'm going to do that. I'm going to do that. May I deal with COM first and then get to the electoral court judgment.
Very well.
Because my submission will be that they misunderstood Kham.
Yeah.
I will deal with Kham only to identify its ratio. I'm not going to read the relevant paragraphs, but may I just give you the paragraphs of Kham, which we submit with respect, capture its ratio. There are a number of them. They are paragraphs 58, 68, 72, 73, 76, 77, 80, and 92 to 94. And the ratio expressed in those paragraphs may be quite succinctly summarized, and that's this. The court set aside the election because of a combination of three flaws. The first and the main flaw was that there were 1,040 of the 3,832 registrations since 2000. So let me just repeat those numbers. New registrations were 3,832. Of those new registrations, 1,040, which constituted 27%, were incorrectly registered, and that irregularity was conceded. The second flaw was that the roll did not include any addresses. So there were no addresses in the roll at all. And that, the court held, was in breach of Section 16.3. The third flaw was that the roll was released late and not by the deadline required by Section 16.2 of the Municipal Electoral Act. And it was the combination of those three factors, those three flaws, which the court held rendered the election not free and fair. But it is clear, if you read these paragraphs, that the most important of those flaws was the first one, the 27% of irregularly registered voters.
Mr. Trengo, are you done on that point? Yeah. You know, I don't know about you, but I find the case to be very difficult, and I want to make the most of your benefit optimally from your collective wisdom before we go. Let me just seek clarification on this point. As we sit and stand here now, what is it that Section 16, subsection 3 requires of the IEC to have done since 2003 for the national voters' roll to be in a correct state? Let's forget a bit about what CAM said, what the Electoral Court said. As the law stands, what obligations does Section 16, subsection 3 impose on the Electoral Court? I beg your pardon, the Electoral Commission, and I'll have another question afterwards. What is it required to do?
16.3 requires the IEC to keep those addresses given to it on registration and then to disclose them to the political parties on request under 16.3.
To the extent that there is non-compliance, what is it that is required of the IEC to do so that the national voters' roll is in an acceptable state at some point, whether at the time the elections are conducted or at some other stage? What is required of the IEC?
Well, we submit that there is no evidence that the roll is flawed. In other words, there's no evidence that the IEC did not discharge that duty. What is common cause the IEC did not do is to go back to find the addresses of the 18 million already on the roll in December 2003. And that is, with respect, what this case is about. Did it have such a duty or not? We submit not.
Well, my question is slightly different. What I need to know is this. If the correct meaning of section 16 subsection 3 is, with effect from December 2003, it was required of the IEC to reflect the addresses that were available to it from that time, so that when political parties require the national voters roll, the addresses apparently required by section 16.3 are reflected there. If anybody gets hold of the national voters roll and realizes that that is not the case, I mean, anybody can just get hold of it, pay the fee, get hold of it, and tell whether there has been compliance or non-compliance. Now, if there hasn't been compliance, what is to be done?
Well, Chief Justice, the question, you speak about the addresses where available, and that's really where the difference between us lies. We accept that the IEC was required from December 2003 to keep the addresses and put them in the roll when disclosed under 16.3. But we do not accept that there was a duty to go back and find the addresses of the 18 million already on the roll. Now, and therefore, when the IEC makes a disclosure under 16.3 today, we submit that that duty is limited to those addresses which it has kept since December 2003, because they are required to be available. It does not include the old addresses of the 18 million people who were already on the roll. Our learned friends interpret 16.3 differently. They say where available doesn't mean the addresses that you have on your system. They say it means the addresses that you are able to find if you go out into the field and in search of addresses. They say that's what where available means. Now, if they are correct, then the IEC did not comply with the Act. So
I'm sorry, I interrupted. Now, you know, you're an experienced counsel, you've acted as a judge. You know, a judge never knows until he or she begins to reflect on the judgment. Indeed. What the correct position is.
Absolutely.
And that explains these many questions. But on the assumption that their interpretation of 16.3 is correct, what then should happen?
Well, that's why...
If on the assumption that there has been non-compliance, what then should happen?
If they are correct that there was a duty on the IEC to find the addresses of the 18 million, then it's clear the IEC did not comply, and then the appeal cannot succeed, and then the alternative direct access application comes into play. So, but it is as stark as that. The question is, did Section 16.3, when it was introduced in December 2003, imply not only that the IEC must henceforth keep addresses, but imply that the IEC must go back and find the addresses of the 18 million?
No, what if it implies that the IEC should have kept the addresses from 2003?
No, we accept that it implies
Except that
yes.
It implies that.
Yes.
Why are we seized with 18 million at all?
Because the case against us is that there are 4,000 people on the roll who don't have addresses and therefore are irregularly registered. We say
Yes.
no, that logic doesn't apply.
And from that you infer that the Electoral Court meant to disenfranchise 18 million people.
Yes.
Is that where it comes from?
Well, yes. And let me...
But did it ever in its judgment deal with 18 million?
It dealt...
Or the historical voters' roll?
No.
No.
No. But what...
So you before us, because you infer from the Electoral Court judgment that it meant that IEC has a duty to correct the historic voters' roll.
Deputy Chief Justice, in fairness to the Electoral Court, may I ask to take you to the 2 paragraphs of their judgment on which we rely. They occur at page 365 of the papers, and it is paragraphs 12 and 13 of the Electoral Court judgment. And you will remember that the background was...
Which volume? Is it 4?
Volume 4.
(316 or 369?
365. 365.
Thank you.
Paragraphs 12 and 13 of the judgment. The background was this. The independents came to court, and the core of their complaint was that there were 4,189 names on the rolls released to them without addresses. That was the cause of action. The case was there is more than 4,000 names on the roll without addresses, and that is irregular because these days all voters must have addresses. And that was the complaint that the court addressed. And it said on that score the following in paragraph 12. The fact that the voters' roll contained registered voters without addresses was common cause. Counsel for the Commission advised this court that the Commission had commenced the cleaning up of the voters' roll, but that the process had not yet been completed. This admission implies that there are indeed voters on the roll, as it was before the Constitutional Court, who should not have been included therein. It was submitted that the removal of voters from the roll would have the effect of disenfranchising them. The argument cannot be sustained. If a voter was wrongly included on the voters' roll, the removal of that voter would not disenfranchise him or her, as he or she should not have been included in the particular voters' roll in the first place. We submit with respect that logic says that where there is a name on the roll without an address, then it means that that voter was irregularly registered and that voter does not belong on the roll. Now, the court did not appreciate, probably because the facts weren't canvassed before it, that what that implied was that the 18 million who are now down to 16 million would be disenfranchised.
No, but where does it imply that? This is a specific case about specific set of facts, and the court may very well have referred to the duty that arose in 2003. And on the face of it, if there is no address, then the registration is irregular.
No,
unless the ANC uses the caveat and say, IEC said there were no addresses available.
but what this...
Sorry.
What this...
But you invite us to make a decision about the historical voters' roll, and I'm probing the cogency, the basis for us making that decision at all.
Well, what I'm addressing...
Why is it before us?
Well, what I'm addressing is the cause of action made by the plaintiffs in this case, by the respondents in this case. The cause of action they made was that there are 4,000 voters on the roll, on the segment of the roll, without addresses. The fact that they do not have addresses means that their registration was irregular. And the court even said, because they don't have addresses, their registration is irregular, and to remove them would not disenfranchise them because they shouldn't have been on the roll in the first place. It is that logic which is incompatible with the fact that there were 18 million people on the roll without addresses when this rule came in.
But why must we telescope the court's judgment? It deals with lack of addresses in Tlokwe, and in it we see 18 million people on the historical roll. Just help me understand, why are we seized with that particular issue?
No, what you asked...
If you say to me, in relation to the 4,000, the court was wrong to assume all of them should have had addresses, it's one argument. Quite another to say this holding endangers existing registrations on the voters' roll.
No, but with respect, we're simply meeting the case made against the IEC. And that case, if I may go back to two sentences of this court, the first and last sentences in paragraph 12. The fact that the voters' roll contained registered voters without addresses was common cause. This admission implies that there are indeed voters on the roll, as was before the Constitutional Court, who should not have been included in it. So the logic upheld by the electoral court was that any voter on the roll without an address is a voter who was irregularly registered and should not be there.
Mr. Trenkov, does the court simply say, like as before the Constitutional Court, here we again have voters without addresses, and this is irregular? But why does that imply that I might be irregularly registered?
Well, because
if I don't have an address?
It misunderstands come judgment. The come judgment, there were two things. Firstly, come held, and it was conceded, that 1,040 of those registrations were wrongly registered. It had nothing to do with the absence of addresses. They were registered in the wrong voting districts. That was the primary concern in come. The secondary concern in come was that there were no addresses given for anybody. So that come does not support the ratio of the electoral court, which says that when there is a voter without an address, the inevitable inference is an illegal registration and a voter that does not belong on the roll. That is this ratio, and that is the basis on which the court held against the IEC. The logic is, if there is a voter without an address, then the voter was irregularly registered and its name has come off. That was the logic of the judgment. And with respect, that logic is correct if our learned friend's case interpretation of the law is the correct one. If there was a duty on the IEC imposed in December 2003, not only going forward to keep addresses on registration, but to go back and find the addresses of the 18 million, then that logic is correct. But if you accept that there was no duty to go back and find the old addresses of people already on the roll, then this logic is flawed, because this logic doesn't allow for the fact that there were already 18 million people on the roll when the rule was introduced in December 2000.
People on the roll from 2003. And the court, there were people who were registered after December 2003. And the electoral court was entitled to infer that the voters' roll must have addresses, because that's the duty. And if there are none, on the face of it, the registration would be regular. What is wrong with that reasoning?
No. Well, what is wrong with this reasoning is it simply says a voter without an address is irregular. It doesn't say a voter without an address is irregular only if the registration took place after December 2003. It didn't inquire into the question whether these registrations occurred before or after December 2003. And what it must always accept is that there are, at least on our interpretation, and we submit on any sensible interpretation of the law and of come, there are two categories of people who will never have addresses. The first is, or need not have addresses. The first is those at the 18 million registered before December 2003, and the other, going forward, those who do not have addresses, who merely have a description of where they live.
Mr. Trenkov, can you please give me your understanding of Part D of the come judgment, and in particular the phrase that relates to the national voters' roll to be used in the ward in that election, including the addresses of all voters.
Yes.
Which voters are we talking about there? Where it says all voters.
Well, it says all voters where these addresses are available.
In pre-203.
No, we submit that that means it is true that 16.3 does impose a duty on the IEC to include addresses where available, where those addresses are available. The question is, what does that mean? We submit that where available means available to the IEC, i.e., on record with the IEC. Our learned friends interpret that to mean capable of being found in the market. We submit with respect that that's a wholly unrealistic interpretation. This section, 16.3, and the court here simply followed the language of 16.3, but this section must be understood against the history of the section. Parliament knew when it was introduced in December 2003 that there's already a voters roll. It already had 18 million people on it. We accept that it implied that you must henceforth keep those addresses on registration. And therefore it said, and then when the political parties want the roll, you must give it to them with those addresses that you have on hand, i.e. those that you have kept since December 2003. It could never have implied that you must also go back and find the addresses. And that's why they said, frankly, that's why they said where available, because they recognized that there are 18 million people for which they don't have addresses available. If they had, they could never have implied that the duty is also to find the addresses of the 18 million, because if that was so, then IEC was in breach of the law on day one, in January 2004, because nobody could conceivably have thought that it could overnight produce the addresses of everybody who has an address out there, in other words, of the 18 million. So,
Mr. Trengo, what in your view is the functional value of the provision or providing of voters' rolls with addresses?
Well, we submit that both the history and the language make that clear. That the history is, we're told, is that in 2003, in the run-up to the 2004 national and provincial elections, the political parties made representations to the IEC and said, won't you please give us the addresses because we need it for our canvassing purposes, for electioneering purposes. The two sections were then introduced in response to that request and said in their own terms that the addresses must now be given, but only to the political parties, and they may only use it for electioneering. And what must be given to them are the addresses where available. And we submit with respect that it recognized that there is already a big roll with lots of people without addresses. And all it said was, yes, we'll give you the addresses where available. We will henceforth keep them and give them to you.
As part of the functional value, can't one also add that it may, besides just canvassing, but it may also be used for purposes of actually checking the accuracy of the registration itself, because we now know that incorrect registrations happen. Tlokwe tells us so. The fraudulent registrations in Ejozini, which I think in paragraph 60 of the replying affidavit the IEC admits, also tells us that this happens. So as part of the functional value, the political parties and independent candidates in the case of municipal elections may use the role to check if indeed the registrations are correct. So it's not just canvassing. Would you accept that as well?
No, with respect, Justice Malanga, we don't. For these reasons. The first is that the history tells us that the purpose was different. The second is that this duty to provide the addresses is only imposed by 16.3 and 4, and that is the duty to give the addresses after certification of the voter's roll. This other consideration, namely this other use that one may make of addresses, and that is to check the voter's roll. There is a process, and Section 15 of the Act describes that process. But there is a process before certification of the roll, where under 16.1 and 2, the roll is available to anybody at any time on request. Political parties can get it and they can check it, and then they may challenge it under Section 15, and those challenges can be adjudicated. But all of that is a process which predates certification of the roll. And the 16.3 and 4, which require the addresses to be disclosed, is the requirement that relates to the certified roll in national and provincial elections.
But surely you cannot say that what the people get given at the time of challenging, in accordance with what you refer us to, will be exactly the same as what finally gets certified
No,
If you accept that it will not necessarily be the same, why is it then that it cannot, the roll with addresses, cannot also be used for the purpose that I put to you?
Because if you look at 16.1 and 2, that's the roll that's ordinarily available to everybody. It says nothing about addresses. And it would be highly anomalous to read an implication in 16.1 and 2 that the addresses must be disclosed to anybody who can use it for any purpose.
I'm talking about political parties and candidates only, Mr. Trango.
Justice Madlanga, we're talking about the role that is made available to everybody in the run-up to certification, in other words, before certification. That role is made available to them under 16.1 and 2. That is an access to the role by anybody at any time for any purpose, without restriction on what they may make of that information. Now, 16.1 and 2 say nothing about the addresses, and we submit that it would be anomalous to interpret 16.1 and 2 to mean that what must be made generally available also includes the addresses.
My focus is on 16.3 and the obligation in terms of 16.3, Mr. Trenkov. So I don't quite see the link between that and 16.1 and 2. I don't see the link. My point was, once certified, is it not so that at a functional level, political parties and candidates may then use the certified role to actually pick up possible inaccurate registrations? As we know that the IEC is not immune to such inaccuracies, Josini tells us so, Tlokwe tells us so. Why is it that it cannot serve that functional value?
No, Justice Madlanga, you're quite correct. It can serve that purpose, and that is the way in which errors in the role can be detected. If you ask me whether it was enacted to serve that purpose, my submission is no. But that it can serve that purpose today, that is so.
Let us, sorry, thank you. Now let us take the point further. I would imagine that the two facets of the functional value which you now accept are not ends in themselves. Would you not accept that they actually serve the section 16, or rather 19.2 and 19.3 right to fair elections? Do they not actually enhance or add value or add content to the exercise of that right? Would you accept that or not?
Well, they certainly...
Putting it differently, if you have an inaccurate voter's roll, that may well give rise to unfair elections, CAM tells us so.
Yes.
And if you have fraudulent registrations, as happened in Josini, which the IEC accepts, again you may have unfair elections.
Yes.
And if again political parties are not given an opportunity to canvass using a voter's roll with addresses, again unfairness in the election process inheres there as well. Would you accept all of those propositions or not?
Justice Madlanga, you asked me really two questions. The one is, can those addresses be used to show up flaws in the voter's roll? And if so, is that a good thing? Yes and yes. It can, and it is a good thing.
I'm taking it further now to section 19 of the Constitution.
May I complete my answer, though? What the section, however, makes clear is that it strikes a balance between the need for addresses for electioneering. Well, let me say, it firstly says it may only be used for election purposes. It doesn't say it may be used to challenge the roll. So the purpose for which it is enacted was to allow the political parties to use the roll for election purposes, for electioneering. But secondly, the section makes it quite clear that it strikes a balance between privacy and politics and electioneering. And it imposes a strict limitation on the political parties to use it only for electioneering and not for any other purpose. So if you ask me, can it be used for other purposes, and is that a beneficial use? That may be so. But the purpose for which Parliament enacted the section was for electioneering, subject to a privacy restriction, because it recognized that the section invades the privacy of people.
No. Oops. I beg your pardon. I beg your pardon. Is the other reason not to ensure that the voter, upon registration, votes at the correct district? Because if he or she is voting at the wrong district,
yes,
because the address was not given as prescribed in the regulations, then it is open to the official to refuse to register.
Indeed, but Justice Nkabinde, that duty to ensure that voters are registered in the correct voting district, that is a duty imposed by Section 8.3. And that duty has always been there, and we accept that if there is a breach of that duty, then the registration is irregular. But that is a duty that exists quite independently of the two further questions. Do we have to keep the address, and do we have to give the address to political parties? Those are two subsequent questions. But you are quite right. The first and primary duty is to register people only in the correct voting district.
Look at, I beg your pardon, if you look at the founding affidavit, on page 105.
Sorry, page?
Page 105.
105.
105. I think we must look first at page 95. I'm looking at the unpaginated volume. It's paragraph 6. Do you have that document? It is the annexure to the founding affidavit, which deals with the ethics and the affirmation statements.
Sorry, Justice Nkabinde, I thought you said it was the founding affidavit. Is it
the founding affidavit in this court?
Is it an annexure to the founding affidavit?
Let me just have a look at, I think it is MSM 6.
And it is page 105, I think you said.
Yes, the document starts at page, immediately after the founding affidavit, after that list of names.
Page 105.
Maybe I should just take you to the document, Mr. Trengove. It's paragraph 6. It is headed required documents. It says the following documents are required for every eligible voter to register in the correct voting district. A valid green barcoded identity document. B, correct and accurate completion of an REC 1 form. C, correct and accurate completion of an REC AS form in cases where the voter does not have a formal address. Now, at 105, this document tells us what should happen if the voter does not have the address. And we know that certain voters did not provide addresses as required in terms of Section 7, read with the regulations. Now, page 105 gives us that document, which is RECAS form. It appears that this document is completed by IEC. That is, in the case where there is no address, the duty is upon IEC to do what's seen to be reflected on 105. Am I correct?
Indeed, Justice Nkabinde, but you must bear in mind that this form RECAS was developed after COME in order to give effect to COME. The IEC jacked up its processes to make sure that it complied with COME, not only in relation to people who have addresses, but also those who don't, and give a narrative description of where they live. And that was why this form was developed, in order to register with the care that COM required. So that is quite correct, but it is a post-COM process.
Thank you very much. But in relation to Appendix 1 in the regulation,
yes,
was that applicable prior to COM
Indeed.
or after?
No. Appendix 1, the REC form, was the form that's always been prescribed. It required the address to be given, but insufficient provision was made for people who don't have addresses but merely a narrative. And that was why, after COM, the additional form REC-AS was developed to cater for those people. But you are quite correct in this sense that the requirement that the REC form be completed, that the voter's address be given, and that the registration officer satisfy themselves that the voter's address falls within the right voting district, that duty has always been there, and we accept that.
And if there are no addresses at all, it means the registering official can refuse to register.
If the voter doesn't give any address, or doesn't give an address which is sufficient to satisfy the voting officer that the address falls within the right voting district, then they can refuse registration. But Justice Nkambini, if I may just emphasize again, that goes to the requirements for registration. That doesn't speak to the two further questions. After registration, do you have to keep the address? And secondly, do you have to give it to the political parties when they ask for it under 16.3? Those are subsequent questions. But at the point of registration, you're quite correct, and that requirement has always been there.
Doesn't it follow that if the initial step is flawed, then the subsequent processes will also be flawed?
Yes, that's absolutely so. But it's common cause that the IEC has, as a matter of course, always followed the procedure of ensuring that the given address falls within the right voting district. So if you say, if that process is flawed, the registration is flawed, yes, we accept that, but that is not the case here. The case is not that at the time of original registration, the IEC did not go through that process of satisfying itself that the given address falls within the voting district. The complaint is you didn't keep that address and you don't give me that address today. That's a different complaint. But the evidence that
Mr. Trango, you, in response to my question, you gave what I see as a very restrictive interpretation of electoral purposes in section 16.4. Why is it that electoral purposes cannot include checking whether or not people have been registered properly? Because that actually relates to the election process. Why can't that be part of electoral purposes, election purposes rather?
Because the process for finalizing the roll is a process catered for under Section 15, and it's a process that is undertaken before certification. I accept that you may use the addresses for a subsequent court case, as was done in this case. So I've accepted that it is possible to use that information to challenge the roll. But if you ask me, for what is the purpose for which Parliament enacted this rule, then my submission is that Parliament enacted 16.3 and 4 not to allow parties to challenge the roll, but to allow parties to use the addresses in their canvassing for an election.
Thank you. I'm not sure what your answer was ultimately to my earlier question on whether what I've referred to as the functional value of the role was. I made the point that is it not so that that functional role value actually goes to the question of the fairness of elections. Do you accept that or not?
No, with respect, let me just understand it correctly. Of course, it's very important that elections be fair. Of course, the role has to be accurate and reliable for elections to be fair. And if there are, and the addresses is one of the ways in which one might check whether the role is accurate. So if you ask me, can addresses be used to ensure that the role is fair and therefore to ensure a fair election?
Well, there was also the further part or facet or on the functional value, which is to assist you in canvassing. And if there are inaccuracies, including fraudulent registrations, that affects that. So in that context, with that context in its totality, would you accept or not that the functional value does bear relevance to the fairness of the elections?
I'm afraid I can't do better than to say addresses can be used to check the role, and an accurate role makes for a fair election. But what we're debating at the moment is the proper interpretation of sections 16(3) and 4. And for the proper interpretation, one looks at the purpose for which that section was enacted. And we submit with respect, the purpose for which it was enacted was not to check the role. The purpose for which it was enacted was to accommodate the political parties' electioneering.
Let me move to my next point then on the basis of an assumption. Assuming that we were to make a holding that there is this connection, there is a connection between the fairness of the elections and what I refer to as the functional value. Would you not accept that this, or rather section 190, subsection 1B of the Constitution becomes relevant? And that is the section that says that the Electoral Commission must ensure that elections are free and fair. And this is not subject to any election, or rather any legislation. This comes directly from the Constitution itself. And unlike paragraph A of subsection 1, which refers to national legislation, this is a standalone obligation on the IEC.
Absolutely.
Yeah. So based on the assumption that I say let us move from, would you accept a proposition that says the obligation on the IEC to have addresses on the voters' roll would have been an obligation that was there pre-December 2003?
No, with respect not. There is nothing in the Act or the Constitution that says you can only have a free and fair election if the addresses of the voters are given in the voters' roll. The IEC always has the duty to ensure free and fair elections, and free and fair elections can only be had on a voters' roll that is substantially accurate. But the mechanism by which one gets there, and whether you include voters' addresses in the roll or not, is not fundamental to the question whether the election is free and fair. Otherwise, you would have to hold that our elections have never been free and fair because there has never been such a voters' roll. And no suggestion in the legislation that one requires those addresses in order to have a free and fair election. At best for our opponents, one may say, addresses are a nice to have because it promotes an accurate role. But you can't for the moment suggest that it is a precondition for a free and fair election.
I thought we can turn attention to something else that just bothers me. If you could ask your Leonard Jr. to give you the Municipal Electoral Act.
Yes, I have some.
Oh, you have it.
Just look at some of its provisions available, Deputy Chair.
I know it predates the 2003 amendment, but look at its provisions, Section 7. Parliament tells us who may vote in municipal elections. And look at 7.2.
Yes.
What should we make of that?
Well, I'm not sure what you mean. What it says is, if somebody arrives at the polling booth and their name is not on the list, but they claim to have properly registered, then there's a process which allows them to vote if they make an affidavit and satisfy the election officer that they are entitled to vote.
Yes, but 7.1 makes quite plain that you vote only in the district where you are registered.
Absolutely.
And that your name would appear in a certified segment of a voter's roll.
Yes.
For that particular voting district.
Yes.
If you claim otherwise, then you have to provide a range of things, and Parliament lists them.
No, not if you claim otherwise. If you claim that you should be on the roll, but you're not.
Yes. If you claim you should be on the roll, but you're not, then you have to provide a whole range of things.
Yes.
And significantly, this, without doubt, includes the obvious thing, the place where you ordinarily reside.
Yes.
Now, talking about functional value, isn't it quite plain in municipal elections in particular? But you can't have fair elections unless you vote in the district where you are properly registered.
Indeed. Absolutely.
And that you determine only by determining where one is ordinarily resident.
Absolutely.
And again, that you determine by being furnished with an address where one lives.
On registration, yes.
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 But isn't that, you've debated several functional values, but isn't that the obvious functional values that we can't hold municipal elections? And that's what we are seized with here, in the Kham case, where there is no meticulous determination of where people reside.
Now, with respect, Deputy Chief Justice, one conflates two things. The first is you're absolutely right that on registration, the address must be given, and the IEC has a duty to check and ensure that that address falls within the right voting district. On that score, there is no doubt, there is no debate, and I agree that the fairness of the election depends on the proper discharge of that duty. And that was why this court held in Kham those elections were flawed, because more than 1,000 of those voters had been wrongly registered. There was an error made at the point of registration. There's a separate question. Having completed that registration, and assume for the moment, one must assume a regular registration, is there a duty to keep that address and to give the address to the political parties when they ask for it? But that is a separate question. If you haven't kept the address, you may have failed in your duty to keep the address, but it doesn't retrospectively render the registration invalid. So that, yes, it is fundamental that people be correctly registered, but no, it is not dependent on whether the address is kept and included in the roll that is disclosed. Chief Justice, I have overshot my time allocation.
Before you go, Mr. Vimpru, I just want to understand what you have given us in volume 5, which is a table that is in paragraph 66.2 in page 421 of the record.
Page 41 of the papers?
Yes.
May I just turn it up? 421.
Volume 5. Now, I think we have now established that Section 16.3 requires that any voter registration from 2003 must include the addresses of voters where they are available. And the IEC is obliged to record the addresses of those voters where they're available for purposes of accommodating political parties. If you have regard to the table, it is notable that a significant number have registered since 2003. Am I correct?
Yes, Justice Kampepe, but you must...
And of the voters who have registered subsequent to 2003, there were no addresses which were captured of those voters. Now, I cannot understand why there has been no concerted attempt on the part of the IEC to attain addresses over the following 13 years. How is that possible? Can you explain it to me?
Yes, Justice Kampepe. These are people who don't have addresses. These people don't have addresses.
And
remember,
in order to ensure that the integrity of the elections are maintained, is there anything anywhere else which explains how the IEC was able to be satisfied that they are ordinarily resident in the voting districts in which they registered? No. If that should be a problem raised by the political parties, how would the IEC assist the political parties in that respect?
Justice Kampepe, these are, let me just recap. You'll see the total of these people is 7.8 million. And you'll remember that at the time the papers were filed, the numbers were broadly that there are 24 odd million voters registered altogether, of which about 8 million don't have addresses at all, and these are they. And then there were another 8 million who are people who have addresses, but their addresses are either incomplete or have not been properly recorded. So there were 16 million people in all for whom there were no or incomplete addresses. But of those people, and in relation to 8 million of them, the addresses simply had not been kept since the time of their registration, and for that reason was not on the voters' roll. But in relation to these people to which you refer, they are people who don't have addresses. They are people who come into the registration to the IEC and say, I don't have an address. I live in such and such an informal settlement next to the spaza shop under the water tower. Here on your map, that is where I live. And then the electoral officer says, show me on the map, and as long as the electoral officer is then satisfied that this person lives in the right voting district, they are then registered. But they don't have an address. There is nothing that one can put in the vote, that one can sensibly put in the voters' roll, because they were registered on the basis of a narrative and an explanation of where they live. And I don't understand our learned friends, for the respondents, to say that addresses must be disclosed for those people who do not have addresses, who merely satisfy the electoral officer by a narrative description that they live within a certain voting district. We all accept that there are 8 million people of that kind who do not have conventional addresses, who can only satisfy the IEC by a narrative description that they live in a particular voting district. And we don't understand our learned friends to contend that that narrative description must in some way be incorporated in the voters' roll. So they are the uncontroversial voters without addresses in the voters' roll. The controversial voters are those people who have addresses but whose addresses aren't there because they historically weren't kept. Thank you.
Mr. Trango, I'm sorry. You've been on your feet for almost 2 hours. Could I just sneak in two quick questions?
Certainly, Justice Chapman.
Can I take you to volume 3, page 268?
Can you tell me what document it is? Because my papers
It's the answering affidavit deposed to by the Chief Electoral Officer.
Page 268.
Of volume 3.
Yes, I have it.
At paragraph 24.2, it seems to me that the Chief Electoral Officer did not understand section 16 sub 3 to be imposing the obligation to seek and obtain addresses upon registration since December 2003. Because here he says, after 30 November, that is the date of delivery of the CAM judgment, the Commission has this obligation, which suggests that from December 2003 until November last year, the Commission did not understand 16 sub 3 as requiring it to ask for addresses, keep them, and provide them to political parties and candidates when elections are held.
In fact, just to add to my brother's question for further clarification, it seems to suggest that the requirement to record addresses never used to exist until the Constitutional Court made it a requirement. Correct.
Let me just make this clear. There are two questions there, and it's important to distinguish between them. The IEC says it has always known that it is necessary to obtain the address from an applicant for registration and to ensure that that address falls within the right voting district. So on the duty, that's the duty under section 8.3 of the Electoral Act. On the process that has to be followed on registration, there has never been any doubt. It has always known what that duty is, and it says, in evidence which is substantially uncontradicted, that that has always been its general practice. What you referred to is the question whether it appreciated that since December 2003, you are required not merely to get the address for registration purposes, but that you are then required to keep that address and to put it on your system and give it to the political parties. That issue, you're quite correct, is not properly canvassed on the papers. They don't say, we realize that there was a duty to do so, and for that reason consistently did so since December 2003. But that issue, nobody has accused them of not keeping the addresses since that date. So that issue as to what their practice was since December 2003 is simply not canvassed on the papers and therefore unclear.
My question is premised on the statement on paragraph 24.2, which says, after 30 November, the Commission has an obligation. And as I understand it, it's the same obligation that is imposed by 16 sub 3.
Indeed, but that's an obligation to keep and disclose addresses. That's got nothing to do with the obligation to get the address at the time of registration to make sure that the person is correctly registered in the right voting district. And
I'm sorry, Mr. Trent, I'm sorry, my brother is still busy with you, but I'm saying it also brings in an unfortunate understanding of the judgment of this court, and that is the impression it inadvertently, and I use the word inadvertently deliberately, inadvertently suggests that before this court's judgment, there was no obligation to do that. It is this court that caused problems for the IEC. 16.3 never used to require the IEC to have addresses recorded, and that's unfortunate because it's not this court that came up with that, it is the legislation itself.
Chief Justice, yes, you're right. The question how the IEC understood and applied that section is never squarely canvassed. What they do say is that after come, we jacked up our processes, we retrained our 51,000 election officers, we put out a new manual, we developed a new form to make sure that we comply with paragraph 5C of the come judgment. And you're quite correct on that score. But what was not canvassed, because it was not raised by either side, is, well, what did you do between December 2003 and the come judgment? That issue is just never canvassed. Justice Jafta, may I just say that what you mustn't infer from the paragraph that you've read is that the IEC was not fastidious in making sure that people were registered in the correct voting districts, because that issue is squarely addressed and canvassed and is substantially uncontradicted. And that evidence is quoted in our heads of argument from page 8 in paragraphs 21 and 22. So the fact that they might not have understood 16.3 doesn't imply that the registration was in any way
much better.
deficient.
Yeah.
They might have been deficient in the duty to keep those addresses and put them in the voters' roll since December 2003.
My second question relates to the debate that we had earlier on with the Deputy Chief Justice about the understanding of the Electoral Court's judgment, the two paragraphs that you referred us to. And my question is, shouldn't really we understand those two paragraphs in the context or the facts of the case? In come, there were about 1,040 irregularly registered voters, which the IEC admitted were irregularly registered. Here again, we have a similar situation. The independent candidates raised an issue in respect of about 4,000 voters. The Commission itself says, I noted that about 4,500 voters may be affected by that. Of that, we have called upon 1,600 voters, given them notices because we have realized that they were registered at incorrect wards. We have called upon them to show cause why their names should not be removed from the roll, which suggests then that even here, on the facts of this case, there are some irregularities relating to about 1,600 voters, which the IEC itself says they were not supposed to have been registered, their names should be removed.
Justice Jafta, I'll have to check the facts because those are not how I understand them.
Okay.
Let me say this. My learned friend, Mr. Marcus, will deal with a suggestion that there was, in this case, voters who were irregularly registered, and I will leave that argument to him. I understood that suggestion to be made in relation to 500 voters and not 1,600, and I'm not sure whether you or I might be confusing, might be confusing the corrective steps they took pursuant to come. But what I address, as opposed to my learned friend Mr. Marcus's address, what I address is the core of the case. The core of the case had nothing to do, or was not that voters had been irregularly registered. The core of the case was that there are 4,000 voters without addresses. And the argument was that if a voter is on the roll without an address, then his registration is invalid. And that is the argument that the Electoral Court accepted, that merely because the voter is on the roll without an address, COM says, according to the understanding of the Electoral Court, COM says those registrations are invalid and therefore should be removed from the roll. That was the ratio of the Electoral Court judgment.
I'm sorry. For the benefit of Mr. Marcus, can I take you to page 262 of the same volume, where the Chief Electoral Officer describes or defines the core complaint? (262), paragraph 7. He says the core complaint of the applicants is that the Commission has not furnished a voter's roll that complies with Section 16 sub 3 of the Electoral Act. In the result, charged the applicants, it has been impossible for them to verify whether the voters whose names appear on the certified voters' roll and are indeed ordinary residents in wards 1, 4, 11, 12, 18, and 20 of Tlokwe, or that they are eligible to vote in those wards.
Yes.
So that's the core complaint.
Yes.
And the IEC, in its letter on page 286 of the same volume, at paragraph 8.10.5, says, after a thorough investigation, 1,601 of the 4,531 persons were confirmed to be located outside their voting districts.
Yes. Well, my learned friend will deal with that issue.
Okay.
But let me say that the paragraph that you read, as opposed to the paragraph that you read from the affidavit, makes the complaint as we understand it. It is a complaint that says there are people on the roll, 4,000 people on the roll without addresses, and that's a violation of Section 16.3 that says you must give us their addresses. It doesn't say that that there was any other irregularity attaching to their registration. And that is, Justice Jafta, where we part company with our learned friends. Their case, upheld by the Electoral Court, is that where there is a name on the list without an address, then the registration is invalid. And that is so only if 16.3 means that the IEC was obliged to go back and find the addresses of the 18 million. It's only on that premise that one can make sense.
Sorry to interrupt you there, and I'm indebted to the Chief Justice. Mr. Trengo, I understand the ANC's argument that Mr. Marcus is going to present to say the COM order has to be interpreted in the light of the shenanigans. Therefore, those 4,500 addressless voters had to be followed up in the context of COM, and therefore there's no question in COM of disenfranchising people or going back to pre-2003 or even before 30 November last year.
No, indeed. And that is because COM found and accepted and conceded that there were irregular registrations. It triggers, of course, a conclusion not only that those people are ineligible to vote, but that the roll is unreliable and should be cleared. But that all
Sorry,
of that,
by supplying addresses.
By supplying addresses. But all of that flows from the fact that there were 27% of the new registrations were conceded to be irregular registrations. That didn't flow merely from the fact that there were people on the roll without addresses. Indeed, in COM, There were no addresses on the roll whatsoever, but the court didn't say for that reason everybody on the roll has been unlawfully registered.
Well, Mr. Trengove, I need clarification on a few things. I think at least twice you have alluded to the entitlement by political parties to the voters' roll that has addresses. I wasn't too sure whether that is intended to suggest that, by the way, these are independent candidates and therefore not entitled to have access to this which the legislation specifically makes available or provides for in relation to political parties. Are independent candidates entitled, or do you take a particular position?
Chief Justice, may I give two answers to the same question? The first is this: I live in a world in which this court is always deemed to be right, and the presumption is irrebuttable. So that, yes.
Even if it might be wrong.
Well, in my world, the court is never wrong. So, and certainly paragraph 5D of its come order says that the section 16.3 also applies to municipal elections. If you were to ask me whether you should consider or reconsider that conclusion, then my submission would be, with the greatest of respect, that the conclusion was based on a premise that the section applies to municipal elections, and that the premise was never interrogated or consciously determined. But there are a variety of reasons why we submit that it doesn't. And may I just say that...
Shouldn't we leave it on the basis that a decision has been taken and nobody has appealed to this court against its own decision?
Certainly we would never... we would accept.
Shouldn't we leave it there? Because unless you really want to make a submission on it.
Now, let me in seriousness say this. We submit with the greatest of respect that the premise of that finding was not correct for a variety of reasons. Both Section 3 of the Electoral Act and Section 3 of the Municipal Electoral Act says that the Electoral Act only applies to national and provincial elections, generally speaking, and applies to municipal elections only if and to the extent that it is made applicable by the Municipal Act. Now, the first fact is that the Municipal Act never makes Section 16.3 and 4 applicable to municipal elections, so that on the face of it, the sections are not meant to apply to municipal elections.
The position is astounding.
May I?
We don't have to debate it now. It's totally astounding. The definition of voters' roll refers to the same definition as in the Elections Act, and it's clearly incorporated by implication. But we don't have to debate that. I mean, the matter is settled.
Yeah.
Your views may be interesting, but I think the matter is settled.
Well, then I have no further submissions to make.
Let me move on to the next question. I'm sorry I provoked you to say, to mention something but didn't allow you to go all the way. The mistake is mine. I apologize to you, Mr. Trengove. Now, the available addresses or addresses available to the IEC. Focusing only on the ordinary grammatical meaning of that phrase, do addresses or physical addresses become available at the to the IEC at the time of registration, or even if they are availed to the IEC at the time of registration, should 16.3 be understood to mean that they may well be made available to you, but if you choose to push them aside or burn them, so that they are no longer available to you, then when political parties come and say, give us the national voters roll that has physical addresses, it then becomes open to the IEC to say, you know what? If you care to know, when they register, they gave me the addresses, but I didn't need them. So they are not available to me. I can't give you the national voters roll that has physical addresses because I chose not to record them. So I'm seeking to understand, is it for the IEC to choose whether or not addresses are to be available, or should availability be understood within the context that there are many settlements in this country, some occasioned by poverty, and therefore people find themselves in a space where their homes are without addresses, and therefore, if you don't have a number, not even a street number, a street name, your address is not available to the IEC at the time of registration. And even if the IEC were to come back to you later, your address would still be unavailable to the IEC because you simply don't have a verifiable a verifiable address in the sense that there is no number or street name. What does it mean?
Chief Justice, we submit with respect that it says one thing expressly and it implies a second thing. The thing that it says expressly is you must disclose the addresses where available. And we submit where available there means, it says where available, yes. And we submit that where available there means if you have them. We accept that it also implies that you must from now on keep all the addresses given to you. But it doesn't say or imply that you must find the addresses, even if you, the historic addresses, even if you no longer have them.
Well, if as at, well, with a fact from December 2003, you are the IEC, here is section 16.3. It says, you know what, when political parties approach you and they want the national voters roll, give them the address, I beg your pardon, the roll that reflects addresses where available. As you register potential voters since the coming into operation of the amendment, is it open, is it to be understood to ever be open to the IEC to say, you're giving me the address, well, I'm not going to record it. And if that were to be the attitude, how then would addresses ever be available if the IEC were not required to record them?
No, Chief Justice, you're quite correct. We submit that since the enactment of 16.3, there's a duty on the IEC, an implied duty on the IEC, to keep the addresses given to it on registration. And that was the duty that this court's order recognized in paragraph 5C. It's precisely that duty. But in conformity with the order, we submit that that is a duty to keep the addresses given to you on registration. That's what the order says, and we submit with the greatest of respect. That order accords with a proper understanding, proper interpretation of 16.3. It does not say or imply that you must also go back and find the addresses of the people already on the roll.
5D reads of the order, it is declared that in all future municipal elections or by-elections, the Electoral Commission is obliged, in terms of Section 16.3 of the Electoral Act 73 of 1998, to provide all candidates in municipal elections on the date on which they are certified with a copy of the segment of the National Voters Roll to be used in that ward, in that election, including the addresses of all voters where these addresses are available. What obligation does 5D impose on the IEC in relation to the addresses? Is it to ensure that since 16.3 apparently requires, just to accommodate your viewpoint, apparently requires of the IEC to have recorded physical addresses since December 2003. Going forward, in the elections to come, the IEC would be expected to have complied with 16.3, or what does it mean?
No, it means exactly that, and you're quite correct.
Yes.
What it means is you must disclose all the addresses where available. We submit where available mean all the addresses you have, and that must be read together with the implication that from December 2003 you must keep all the addresses given to you, so that we accept that that duty includes a duty to disclose the addresses of all those people who registered from December 2003.
Now, purely on the basis that there is a need to avoid any further embarrassment by the IEC. I mean, the IEC has maintained an admirable credibility, I think, over the years.
Yeah.
Just to avoid giving anybody a reason to question the effectiveness of the IEC and its capability to discharge its constitutional mandate properly. Does 5D not impose an obligation also on the IEC to go back so far as practicable and check in relation to all other?
No, with respect, Chief Justice, COM simply didn't consider that question.
Yes.
It didn't consider, it's simply that where available in 5D correctly recites the language of the section of 16.3, and it is absolutely correct as far as it goes. What COM never considered is what that means. We accept, and so that COM doesn't guide us on the meaning of that language. We accept that it means at least that the IEC must, since December 2003, have kept all the addresses of new registrations, and that those addresses have to be disclosed under 16.3. The question that COM doesn't answer is whether the IEC was also obliged to go back and find the addresses of the 18 million who were already on the roll in December 2003. And frankly,
after those who were enrolled after December 2003,
no.
What do you understand it does it require? Does 5D require of the IEC to make sure that those are properly registered?
I'm not sure that that is what 5D says, but we accept that the duty under 5D is a duty that must be read with the implication arising from 16.3, that all the addresses must be kept from December 2003. So 16.3 and 5D read together both say that you must disclose all the addresses of all the voters that you have, and you must at least have those addresses of voters who registered since December 2003. That much we accept.
On the assumption that the IEC is expected as a time of the certification of the national voters roll to reflect known addresses, and dealing with a question that it's a near impossible task to accomplish, what is to be done?
No,
what can be done? Maybe we should start there.
It depends on what you mean by known addresses, because they already reflect all the addresses now known to the IEC.
Let me give an example then.
But if you mean addresses disclosed to them in 1999, which they have since then lost, then that's a different issue.
No, that's not what I mean. This is what I mean. Maybe my first question should be prefaced with another question. How long does it take that South Africa to conduct a census? Generally, do you have an idea? Is it a year? Is it 6 months?
It's a question of months, but I'm not sure how long.
And as I understand it, Stats SA, according to the papers before us, is one of the agencies in a committee roped in, I think by the minister, to help track down the addresses of those who are registered without addresses.
I would imagine.
That's my understanding of the papers before us. Now, if Stats SA is able to do this within months and is available and willing to assist the IEC, why does the IEC need 4 years to accomplish the same task?
Chief Justice, let me say, I can merely tell you what the IEC says, why it would take them so long. I don't understand Stats SA to have a reliable list of addresses of everybody. In fact, one knows that they do their population counts often on aerial photographs and extrapolations of samples. So the suggestion that they have a reliable list of addresses of everybody in the country is not accepted by my client.
I don't know how I wanted to know whether they do it in months, because I know they do visit us in our homes. They even ask you about your salary. So I wanted to find out if they can do that within months. Yes, they interviewed me several times. If they can do that within months, and we're trying to make sure, all of us, I believe, that the elections proceed as planned, so far as possible.
Yes.
If they can assist the process, and this thing can be accomplished within months, does it not then create a possibility that what we thought could only be done after 4 years might be done much earlier?
Chief Justice, my clients who are the experts in this area say no, and they in fact deal with it in 2 places. They deal with it in their founding affidavit from page 428 in paragraphs 74 and 75.
I've seen that.
But the more interesting part, because is in the reply, where they also address where they also deal with the criticism of their prognostication. In reply, they deal with it from page 897 in paragraphs 15 to 17. And let me just say this, that one thing that I understand from my client is that there's a correlation between time and money. And one can't simply say to them, do it more quickly, because more quickly requires more resources and it is more costly. So one would always have to strike a balance.
Because it may impact on the preparation for the elections, I suppose.
No, but indeed. And we all agreed that this is an important project, but you just had a little sample of these 2 weekends that they organized that cost hundreds of millions of rands. To imagine how much it will cost to recover the addresses of the outstanding 12 million people. So that we submit with respect that we have their best estimate of the time it will take them, and that is at least until 1919. If the court is not satisfied with that best estimate, then the only other alternative would be to make a let's see how we go order, which says take certain steps between now and the end of next year and report back, and we will monitor you as you go along. But what you can't do with respect is to make an order inconsistent with what they say is their best estimate of the best they can do, simply because we as lay people are critical of their assessment, because that may be ordering them to do something which they have said they can't do and which they may turn out to be unable to do.
Well, the bottom line is always this, though, Mr. Trengove. Whatever a party's position is, it remains the responsibility of that party to articulate its position clearly and fully in court, rather than give the court an incomplete story, and when the outcome is not favorable, to then give a fuller picture outside.
Yeah.
We need a fuller picture here so that it can guide us as lay people to arrive at a correct decision.
I submit with respect, if you look at their paragraphs 15 to 17 of their reply, that that's exactly what they do. But if the court is not satisfied, or if there are further matters that the court wishes to interrogate, then by all means, my client offers its full cooperation. What I submit would be irresponsible to do is simply to cut their estimate by half on the basis that they must, on some basis or other, achieve what they say is impossible.
Irresponsible from which side?
No. All I submit is one shouldn't arbitrarily depart from the estimate that they make.
Talking about responsibility, are you still urging us that we run the 2019 elections on what might be a defective voters' roll?
Yes.
Does the time extend beyond 2019?
They have said that their best estimate is that they will be able to find all the addresses by the end of 1919, and that's why they have asked for time until June 2020.
What is the estimate in relation to the obvious obligation that sits in Section 16? What about addresses which they're obligated to keep and record from December 2003? How long will that take?
They have not.
Understand, and we're talking about historical role. Whether it is before us or not, we will decide. If it is before us, is one debate. If it is not, what probably will be in any event before us is certainly the duty from 2003. How long would they rectify that?
That issue is not canvassed on the papers, so it's not clear that those addresses aren't already on the roll anyway, or if they're not, how long it will take to get them. So, Deputy Chief Justice, I simply can't answer that question because that issue was never canvassed on the paper.
The calculation, you remember the question from my sister Justice Khampepe, of the 18 million much vaunted everywhere in the public space, includes registrations after 2003, doesn't it?
No.
No.
No. Those were the people who were already on the roll in 2003.
The roll by 2003?
Yes.
If we took the view that there was a duty, in fact we haven't come, from December 2003, would the IEC need any time to rectify the roll from 2003?
That issue is not canvassed on the papers, so we don't know whether the roll doesn't already include them, or if it doesn't, how long it would take to get them.
Well, you might have to get instructions on that, because the debate does drift in that way, Mr. Trengove.
No,
for instance...
Yes, I shall do so, but it would be an issue that would require careful consideration, because there's both a determination of what is lacking, if anything, and then an assessment of what it will require to supplement.
I'll show you what my difficulty is. If we were to take the view that there's no basis and reason for reopening the details currently recorded up to 2003, and that there was no such duty, assuming we go along with you on that, then the only question would be from December 2003. And suddenly the moratorium beyond 2019 takes a different picture. And that is why I am urging it upon you that you take instructions on the matter, and we might hear you on...
Certainly, Deputy Chief Justice. May I just say this, though, that was not the case made in the electoral court or on the papers in this court. It would be a new case, and I will certainly take those instructions, but that is not what this case has been about.
Mr. Trengove, I mean, a bit of sophistry there. You see, in Kham, the decision is based on the obligation that pre-exists set by Parliament in Section 16, 3 and 4. So we didn't create new law. Chief Justice made the point over and over again. We articulated a duty that pre-existed. So if we are going to deal with this section at all, we may very well hold that the duty was always there from 2003 December.
But that's uncontroversial, Deputy Chief Justice.
Yes, and the question is, then the IEC would not need any time at all to remedy the voters' roll. Is that right?
No.
If the cut-off point is December 2003.
I'm afraid I can only say, as I've said before, that issue is not canvassed on the papers, and for that reason I don't know what the answer to that question is. My impression is that they did keep and record those addresses, but how fastidious they were, how thorough they were in doing so, I simply don't know, and I can't give you any assurances. So if your question is that if you postulate that they were not required to go back to find the addresses of those already on the roll in December 2003, but they were required to do so since then, and you ask me to what extent did they do so, and if not, to what extent, how much time do they need to complete that task, then I simply don't know, because those issues aren't canvassed.
It goes to the direct access application, so it would be helpful to hear your clients on that in reply, or they may seek leave to give us the facts in another way. Thanks.
I'll certainly ask the questions, Deputy Chief Justice.
Before we adjourn, because we're going to adjourn now, and this is for all counsel, we still have to hear 6 others, and it's already 12:30. So we may have to cut down on the lunch hour. Just check whether 30 minutes would be enough for lunch, and also what time can we break for lunch. We never used to adjourn for lunch in cases like this in the past until I was advised that not everybody can be without food. So reflect on that and let us know, and also if you could really narrow down on issues that each must deal with. We don't have to repeat what has been traversed before we come on to speak. Otherwise, the court will adjourn until just after 1:15.
As you heard there, they are taking a short break at the Constitutional Court this morning, hearing an application by the independent
Yes, Mr. Turnbull.
Chief Justice, may I just respond to the inquiry of the Deputy Chief Justice? I did indeed, as he suggested, obtain instructions. And the instructions are as follows. The IEC's practice since December 2003 was to record on its system all the addresses given to it by people who applied for registration. But there is a time lapse, or there was often a time lapse between registration and the recordal. They say typically people would, there would be a registration drive just before an election. A large number of people would register. They would keep all their addresses, but get round to recording those addresses on their system only after the election, because they would be engaged in the election. So some months would go by before they are recorded. There were occasions, and they can say today that they have recorded all of the addresses, all of those addresses that they have available. But there have been instances where some of those addresses have been lost. There was a fire in a warehouse in KZN, and there was a flooding on some other place. So some addresses have been lost.
In some provinces, not all.
No, in some mishaps which were out of the ordinary. So as a general rule, they recorded all of the addresses of all of the people who applied and who had addresses. The only exception is that there were the odd exceptional mishap which caused addresses to be lost. So the only addresses which, since then, only people who have been registered without addresses are two categories of people. The first is those whose address went missing as a result of these mishaps, and the second are those people who do not have addresses. One thing that they did not do before COM was to keep a record of the narrative description of those people who do not have addresses. Pursuant to COM, they formed RECAS for that purpose. So the big difference COM made was that they now keep the narrative description of those people who do not have addresses. But that narrative description still doesn't go into the voters' roll because they don't understand that to be an address. So the people on the roll today who registered since 2003, for whom there is no address, by far the overwhelming majority of them are people who don't have addresses. But there are some of them who were the product of these mishaps who have addresses but whose addresses aren't registered on the system.
Let me just make, you want to round up?
As to how long it will take to find the addresses for the latter category, the mishap category, they simply don't know. They would have to go back to their systems to see if they can identify them. But what they can say in general terms is that they can't do so in time for the 2016 local government elections, but they would be able to do so in time for the 2019 national and provincial elections.
Let me just make sure I understand the clarification. Does the IEC know how many of those whose addresses they had whose addresses they had, their addresses were affected by the mishaps?
No.
So as to be able to determine whether this problem can be resolved within a matter of months or not, because you're only able to say it will take long if you know whether it's 5 people or 500,000 or 2 million people. Is there a sense of how many people are affected who had disclosed their addresses?
Chief Justice, may I go back to the table that Justice Kampepe referred to at page 422 of the papers, because it gives us the numbers of people who have been registered since 2003 who do not have addresses. And you'll see they are the people registered on that table at 422 from the year 2004. Now, all the best that my client can do as they stand here is to say that by far the overwhelming majority of those people are people who do not have addresses. But they can't say precisely what numbers are the people who do not have addresses on the one hand and those whose addresses they've lost on the other. That is that, except to say that the former category is by far the overwhelming majority, they can't be more accurate as they
Well, the number of those registered, and I'm just doing a rough estimate, having looked at 2000 to 2002, the number from 2003 is about just over 7 million people.
Well,
yes, because you have 355,000 plus 15,000 plus 24,000. That's certainly much less or lower than the 800,000 that stands there beyond the 7 million.
Yeah, but the 7 million includes, on the previous page, about 2 million people.
As well. I'm sorry. I made a mistake then. I beg your pardon. So would it be roughly
it's 5 million?
Roughly 5 million. Now, do we know more or less, without committing itself to anything, from the IEC's perspective, more or less, how many of the 5 million are without addresses and in which provinces? KZN affected by fire, which other province affected by what?
No, I'm afraid I don't. What they told me is that they are unable to tell you today what that number is as they stand here. They can't do better than to say that they know for certain that by far the overwhelming majority of the 5 million are people who do not have addresses. But they can't be more accurate.
Okay, but there was an incident in KwaZulu-Natal.
Let me say, I didn't ask them for a catalogue of incidents.
Yes.
In telling me why certain addresses had gone missing, they say, for instance, there was an incident at a warehouse in KZN which was either flooded or burned down. And so I mentioned that example, but I didn't ask them to list all of the causes of lost registration forms. That certainly can be given, but my client would need some time to collect its information and give it to you if you so wish.
It would, I don't know, subject to what colleagues have to say, it would help a lot because the more information you have relevant to the decision you have to make, the easier it will be to come up with a decision that is backed up by facts. The difficulty, as I said earlier, Mr. Turngrove, is to have an incomplete account of the problems or the challenges that confront the IEC, make a decision, and subsequently be accused of having been unfair to the IEC when you are not favored with the information you require to arrive at a decision.
No, certainly, Chief Justice. If I understand then what you wish them to give you are the causes of addresses going missing since 2003.
It would help to have that information and also, say incidents where, how, and is it the entire province, is it a region? And obviously when these things happen, a fire and so on, you'll have them recorded. In the media, can even attach some media clips to say IEC warehouse with records raised by fire or something, just to give us a sense of what's happening. Obviously, the other parties, I'm sure, may have to respond. But what I say to you is subject to the attitude of your colleagues when they rise to address us.
Thank you, Chief Justice.
Yes.
Before you sit down, the other thing that I didn't quite follow well, where addresses were provided, but were not recorded.
Addresses were?
Where addresses were provided, but were not immediately recorded, but only recorded months after the elections. But aren't the addresses necessary for the voters' roll that's given to the parties? Do you understand my difficulty?
Yes.
In other words, 16.3 tells us that you need addresses and they have to be furnished to political parties.
Yes.
If you record them long after the elections, I don't quite follow how.
No, I understand the question, and I however, do not have the answer. I didn't ask that question, and I shall do so.
It's difficult to understand because my limited understanding says it is not on the day of the elections that you record people's particulars. There's a period such as the one we have passed through when we all invited to come and verify the correctness of the information on the voters' roll, and new would-be candidate register their names. That's when you capture the information, and that's when you can, if you are able to, factor it into the voters' roll to be verified in due course. So I understand you record them, they are here, they are available, but you will only wait for the elections to come first, and thereafter I don't understand it. So clarification would help in due course.
Yeah, let me just explain how I understood it, but it doesn't answer the Deputy Chief Justice's question, and that's this. There is invariably, before certification for an election, a huge registration drive. That registration drive attracts a lot of registrations. You'll see in that list, there's 1 year where more than 1 million people are listed. That is in a registration drive in the run-up to an election. And they say that those people are then registered and their forms are kept. But because there are so many of them, and because the IEC is so heavily engaged in the run-up to the election, those people only get recorded on the system after the election is done. It raises the Deputy Chief Justice's question, how do you reconcile that with your duty to give the political parties a role with the addresses if those addresses aren't immediately recorded? Well, I'll have to get an answer to that question.
Well, what I don't understand is, as you register those new would-be voters,
yes,
as you insert their particulars in the roll, why leave out the address if the plan is to also include the addresses there as well? I don't understand it, but anyway, that's by the way.
Yeah, I'll certainly raise that question, Chief Justice. Thank you, Chief Justice.
Thank you, Mr. Trengove. Mr. Marcus. You need 10 minutes?
If I'm afforded my immunity, I undertake to cut down my argument to not more than 20 minutes.
All right.
Thank you. Chief Justice, with your leave, I propose to address 3 issues which flow directly from the appeal from the Electoral Court, and they go to the correctness or otherwise of the Electoral Court's decision. The first issue concerns the proper interpretation of the word available in section 16.3 of the Act. The second is merely one additional submission to that already advanced by my learned friend concerning the proper interpretation of the CAM order. And lastly, we will address the question of what was the actual complaint which served before the Electoral Court, and what was it that they were called upon to adjudicate. If I can then turn to the first of those 3 issues, and it's the meaning of the word available. The debate between the parties before this court really turns on 2 possible meanings of the word available. On the one hand, there is the interpretation which the IEC advances and which the ANC supports, and that is that available means available to the IEC on its record-keeping systems. In other words, the addresses which it actually has on its record-keeping systems. The competing interpretation, which is advanced by some of the parties before the court, is that the word available means that the IEC is under an obligation to provide a roll with the address of every registered voter who has an address. So available in that context and on that argument means where it objectively exists. In support of the interpretation which we advance and which the IEC advances, we have found an authority which we submit is of analogical assistance to this court. It's the case of Reynolds Brothers versus the Chairman Local Road Transportation Board, and it's 1985, volume 2 of the South African Law Reports, page 790, Appellate's Division. And it concerned that phrase contained in Section 18 of the Road Transportation Act, and leaving out unnecessary wording, it said that in an application for a road carrier permit, the board shall not application unless it is satisfied in the circumstances to expect the applicant to make use of any available railway service for the conveyance of goods to which the application relates. Now, I don't want to get into the facts of the case because obviously the court will read that for themselves, but the issue was really whether a railway depot some 100 kilometres from the mill in question was an available railway service. The board had refused the permit. The company took it on review, and the High Court had taken the view, in rejecting the review, that there was no warrant for concluding that the legislature intended that the railway service should be immediately or readily or conveniently or economically available, or that any particular degree of availability was intended. And it was that decision which was reversed by the Appellate's Division, and the critical passage which we commend to this court is at page 804, where the court said this: "The legislature did not intend that railway services were to be regarded as being available, regardless of their distance from the place of business of those for whom the services were to be available. In case of doubt, a realistic rather than a highly unrealistic concept of availability would be attributed to the legislature." And that, with respect, is the approach which we submit is the appropriate one in a case such as this. And so we therefore submit on that point that available means the addresses which the IEC has on its system. If I could then turn to the second point, which turns on the proper interpretation of the CAM order. As we understand it, several of the respondents argue that the CAM order imposes an obligation on the IEC to produce a voter's roll with addresses to the extent that they are available of persons who, for example, registered prior to the 2003 amendment, and indeed to those who registered thereafter but before the CAM order. Purely by way of example, the DA makes that argument at pages 23 to 24, paragraph 23 of their heads. What we would submit would be of assistance in the proper approach to what the CAM order says, is to have regard to paragraph 6 of the order, because that is the operative order which regulates the prospectivity of the orders in both 5C and D. And what we would with respect point out is that paragraph 6 of the order is in two parts, separated by the conjunction and. It reads, "The orders in 5C and D are prospective in their operation from the date of this order and do not affect the validity of any election or by-election held prior to the date of this order." Now, it is true that those two parts have been conjoined in one order, but we submit that their effect would have been identical if they had been separated in two separate orders. And we would with respect submit that the first part of the order, which speaks of the prospective operation, stands quite independently of the second part, which turns purely on the effect of the order on the validity of elections which have already taken place. What we would submit, flowing from those two submissions, is that the Electoral Court misinterpreted and therefore misapplied the court's order this court's order in CAM, firstly, by finding that Section 16.3 obliged the IEC to provide the candidates with all the addresses of registered voters and not only those that had been entered on the IEC systems. And the second error we submit the court made was by extending the IEC's obligations to obtain particularity of historically registered voters despite the prospective operation of Order 5 by virtue of paragraph 6 of the order. What we would submit is that that error, of course, induced a wrong outcome. But in order to get to that point, which is the third of my submissions, it's critically important we would submit to properly identify the complaint which served before the Electoral Court. Now, as we see it, the core complaint was that the voters' roll which had been supplied to political parties did not record the addresses of some 4,160 voters whose names appeared on the roll. And that appears to be indeed really the only issue which was advanced, if one has regard to the way it was formulated by the applicants in the Electoral Court at paragraph 3.4 in volume 1 of the record. It says the first respondent is in practical terms and by virtue of the belief and decision in 3.3 above of the view there is no duty or obligation on the first respondent to provide the applicants with the addresses of an extent of 4,126 voters that have been registered to vote in the Tlokwe by-elections and of whom no physical addresses appear on the certified roll.
Please give me that reference, Mr. Marcus.
It's in volume 1, it's page 15, and it's paragraph 3.4, which would also need to be read with page 19, paragraph 4.8. There we are told that on the 16th of February, we instructed our attorneys of record to record the results of the investigation as an official complaint with the first respondent. This was done in a letter of even date attached here to his PM3. In the said letter, we recorded various complaints, but of relevance to this application, stress that, is the fact that we detected and indicated in paragraph 4 thereof an amount of 4,160 voters in wards 1, etc., that have no physical addresses reflected on the voters' roll. And if you go to the letter of complaint, which is referred to in that paragraph, it's Annexure PM3, which begins on page 55, but the relevant paragraphs are on page 56. Once again, you will see in paragraph 4, it says, ex facie the contents of the voters' roll provided to our client with paragraph C and D, paragraphs of the order of the Constitutional Court, in that the following numbers of registered voters in each respective wards of the by-elections does not reflect a verified address of the voters, and you can see the total is 4,162. And then I draw attention to what is in 5, because this is an additional complaint. It says, apart from the above-mentioned non-compliance with the order of the Constitutional Court, our respective clients' own investigations with regard to voters that are currently wrongly registered in the wards where the by-elections are due to take place reveals the following numbers of illegally registered voters per ward, and that is where we get the figure of 565. So, what is absolutely clear is that the mere complaint, the core complaint, indeed the one which the Electoral Court considered concerning the 4,000 odd voters, was a complaint of the absence of addresses simpliciter, nothing else. The complaint was merely that we have gone through the roll, we've identified 4,160 voters' names who's there are no addresses linked to this. Now, in our respectful submission, based upon this court's judgment, the submissions that you've heard, The absence of an address cannot in and of itself constitute an irregularity. That flows from section 16.3, which, as we know, only requires the address where it is available, and therefore the mere fact, the mere absence of an address is not an irregularity. As for the 565, if there was evidence to justify the assertion, because it was nothing more than an assertion, that there were 565 voters who were actually residents in districts in which they were not ordinarily resident, that would certainly constitute an irregularity, the degree and effect of which would of course have to be independently assessed.
The 10 minutes has expired.
Thank you.
So proceed with that on that understanding.
In relation to the 565, I beg your pardon.
The mere appearance of somebody on a voter's roll without an address is prima facie unlawful. It calls for an explanation, doesn't it? Section 16 tells us you must have an address.
Where
it is
available?
available.
Well, the explanation...
So the caveat requires an explanation. Here, it is not available, but the default position is you will have an address inserted. Isn't it so?
Justice Moseneke, I'm slightly hesitant to say prima facie unlawful, but I accept the core proposition which you are putting to me, that it calls for an explanation.
Yes, the law says you must have an address.
Yes.
Except if it's available, whatever available means. So it calls for an explanation. Sorry, there's no address because it is not available. Otherwise, on the face of it, it's an illegality, isn't it?
The IEC provided an explanation. The explanation is to be found in the... And again, I'm confining myself at this point to the case before the Electoral Court, because as I will demonstrate in a moment, there is what we would respectfully submit to be an impermissible attempt to raise the spectre of the 500 in this court, but I'll come to that. In the Electoral Court, the IEC advanced an explanation, and it's to be found in their answering affidavit, volume 3.
In which court? In
the Electoral Court.
Yes.
And their explanation is in volume 3, page 278, at paragraph 35. And in summary, what their explanation is that the 4,160 fell into two categories. The first was those who had registered before the CAM order, and the second was those who had registered after the CAM order, but where the voters did not have a physical address. So the IEC did indeed offer an explanation, and that is the one to which I have referred. But in relation to the 500, if there was evidence before the Electoral Court that they were indeed registered in the wrong ward, in the sense that they were registered in an area where they were not ordinarily resident, then that would constitute an irregularity, and its seriousness would depend upon the relevant facts. But the Electoral Court had no evidence before it whatsoever, other than the mere assertion that there were some 565 falling into this category. They were not told anything about how that 565 had been identified, other than that it was the product of an investigation, the details of which were never ever disclosed to the Electoral Court at all. And indeed, if one goes to the judgment, it appears that the Electoral Court didn't deal with those 500 at all.
I'm sorry, Mr. Marcus. What about the report contained in the letter attached to the answering affidavit of the IEC, where the IEC says, we have investigated. In fact, we find that about 4,531 people are affected. Of those, 1,601, we have sent notices to the various voters to show cause why their names should not be removed from the roll, because it says they were registered in wards in respect of which they had not given addresses. Their addresses referred them elsewhere.
Justice Jafta, that is correct. If you go to the letter, the explanation to which I gave the reference in their answering affidavit is to be found also in that letter. It's on page 210 in paragraph 8.6, where they answer specifically the complaint in paragraph 4 of the complaint, that is the one to which I refer, and they give the explanation that follows. And in addition to that, they give details of what they have done in order to remedy the defects which had arisen. And in addition to that, they address themselves to the 565. You will see that in paragraph 8.9 and following. All I am saying...
My question is directed at what they say at 8.10.5.
Yes.
Because that gives an impression that as the facts were before the Electoral Court, there was a number of people, at least 1,600 of them, which the IEC itself, on investigation, found that they had been irregularly registered.
Justice Jafta, there's no dispute about that. That was the product, however, of the IEC's own investigation and the steps that they took to put it right. My point is a slightly different one. My point is, what was the complaint that the independents brought to the Electoral Court which gave rise to this very dispute?
Mr. Bakas, I'm sorry to interrupt you. I was just pointing you to those facts in the context of the criticism leveled against the Electoral Court to the effect that there were no facts before it indicating any irregularities.
Justice Jafta, I think we're at cross purposes. There are two... The way the complaint was formulated in the original letter of complaint was twofold. There was one complaint about the 4,160, and there was a second complaint about the 500 odd. The complaints were different. The complaints about the 4,160 was the mere absence of addresses. Nothing more, nothing less. The complaint about the 500 was different. The complaint about the 500 was that they were wrongly and therefore unlawfully registered in wards in which they were not entitled to be registered. The Electoral Court didn't deal with that latter complaint because, in a sense, they were not really called upon to do so. The way the argument was framed in the Electoral Court focused purely on the 4,000, and the complaint in that regard was the mere absence of addresses. Yes, it is absolutely correct, as you have pointed out to me, that the IEC, perhaps pursuant to its duties, took steps to investigate how it is that there were 4,000 odd without addresses, and we know the results of that investigation. All I am saying is that was not the complaint which served before the Electoral Court.
There's an obvious incongruity there, Mr. Marcus.
I beg your pardon, Justice?
I understand. I said there's obvious incongruity there. Remember where we started when my brother, Justice Jafta, came in? You were saying the court was wrong because the only complaint before it was that there are 4,000 people whose addresses are not available. On that ground alone, it held against the IEC.
Yes.
And yet, in fact, if you go to the court's decision, you can see in paragraph 12, I think that's where it makes its factual finding. The question is, what is wrong with that finding? Let me see. No, yeah. In 12, it says the fact that the voters' roll contained registered voters without addresses was common cause. Counsel for the Commission advises court that the Commission had commenced the cleaning up of the voters' roll, which coincided with the annexure, of course, provided by the IEC, but that the process had not been completed. This admission implies that there are indeed voters on the roll, as it was before the Constitutional Court, who should not have been included. Now, if you go and look at what my brother Justice Jafta referred to on page 211, and look at 8.10.5, there the IEC says, after a thorough investigation, 1,608 of the 4,531 persons were confirmed to be located outside of their voting district based on the addresses provided. Accordingly, the Commission sent notices to 1,601 persons notifying them of its intention to remove them from their names from those segments of the voters' roll and requested them to make representation in respect thereof. Yes. Of these, 1,509 persons were removed from the affected segment and re-registered in their correct voting district. Now that is inconsistent with a mere answer that says the addresses are not available.
Yes. Justice Moseneke and Justice Jafta, you'll appreciate that this letter was written before this application was launched. So the question was, in the face of what the applicants in the electoral court knew the IEC had done, what was their complaint then? This was information that they had. They had been told that this is what the IEC had done because there was a build-up to this court case.
Well, the electoral court tells us what the complaint is.
I beg your pardon?
It doesn't have to be reformulated. The electoral court tells us what the complaint is. Look at page 363 in his judgment. It tells us. And then it proceeds to make factual findings on the basis of concessions by the IEC. And then says, well, not much has happened. You're still cleaning up the voters' roll, and there are people who, on your admission, should not be there. You've given others notices not to be there. And therefore, and it says, you are pretty much at the same place as where you were before the Constitutional Court. And therefore, the claim is valid. Why is that wrong reasoning?
The reasoning has to be directed to what the complaint was that served before it and what the evidence was to support that complaint. There was certainly a build-up towards the application in the electoral court in which the IEC had been notified that the central complaint was that there were 4,000 odd names on the roll without addresses. The IEC addressed that complaint in the letter to which Justice Jafta and you have both referred, and thereafter the independents came to court and their case before the electoral court was unequivocally a simple case. The mere existence of 4,000 odd names on the roll without addresses was what they contended to be a fatal irregularity. Now, I would with respect submit that that was a misappreciation of what in fact the case was that they brought to the court, what the electoral court was called upon to adjudicate, and of course the eventual outcome would have been infected by what we submit to be those misdirections. I do accept that in relation to the 500, had it been established, that certainly would have presented a problem. The difficulty, however, was before the electoral court, there was no evidence whatsoever other than the mere assertion concerning the presence of those 500 names. What has happened in this court is there is an attempt on these papers to introduce new evidence that was not available before the electoral court.
But I think the point, sorry for interrupting Mr. Marcus, is that this is a symptomatology. That the absence of addresses gives rise to disquiet on the part of the independents, and their own investigation, which they might not be able to prove for the purposes of their application in the electoral court, underscores their anxieties because of all these unaddressed registered voters. And as Justice Jafta points out, the IEC's own investigation substantially bears out those anxieties.
I understand at the level of a perception, or however one puts it, that where one encounters a significant number of voters without addresses, the question arises, well, why is this? And I can equally understand a party perhaps drawing the inference, not in the technical legal sense of the word, well, there may be an irregularity here. Once they had done that, the IEC addressed the problem. If this court were to hold that the IEC addressed the problem inadequately, then the argument that I advance will carry no water. What we would submit, however, is that two things. Not only did the IEC address the problem, but at a point after it had been addressed, and the applicants before the Electoral Court knowing what the IEC had done, they came to court not on the basis that you haven't done a proper job, not on the basis that your investigations were inadequate, but purely on the basis that they have identified voters who do not have any recorded addresses. That was the case. Theirs was not an attack on what the IEC had or hadn't done. What we
Mr.
would...
Marcus, I'm sorry.
Yes.
Of the 1,600, we know that the IEC determined that they were incorrectly registered because they had provided addresses. Of the rest, the balance,
yes,
the explanation is that addresses were not provided because they were not available. Am I correct?
That's my reading of it, Justice Jefter, because
Yes.
you have to read paragraph 8.6 before that together with 8.10.
Yes.
Yes.
Correct. Now, my difficulty is, how did the IEC, because seemingly, when one looks at the background, the IEC did not know from the outset why 4,500 voters did not have their addresses. They had to investigate. They investigated. Now, I'm curious to know, what was it that the IEC found in respect of the balance, that they were properly registered in the correct wards, even though their addresses were not available?
Well, Justice Jefter, given whom I represent, I can't answer that question. But I suppose the second part to that question is, I think in fairness to the IEC, that is not a question they were called upon to answer. So the short answer, I perfectly understand the curiosity underlying your question, and it's a natural question to pose. But I can't answer it, and I don't believe, in all fairness, that the IEC was called upon to answer it either.
And in all fairness, how would the independent candidates know that what the IEC say is correct? If the IEC says those people were correctly registered, even though we don't have their addresses, what are the objective facts to show that?
Well, I appreciate the dilemma in which the independents found themselves. I can do nothing more than reiterate that had they squarely posed the challenge, perhaps my answer, my learned friend's answer, would have been different. And that's why this is not a, can I stress, this is, I don't want to be misunderstood as suggesting or implying that this is a mere technical point about pleading. The point about this is that it all happened urgently. There was very, very little time. And in those circumstances, of course, things can fall through the cracks. But at a very minimum, in fairness to the IEC, they came to court on the particular case that had been advanced. And what we are seeing here in this court, certainly in relation to the 500, is the presentation of evidence which was simply not placed before the Electoral Court. And on that score, we would simply say this. We would say, first of all, it is not permissible for them to do so now. But more importantly, yes.
But it seems to me the IEC understood their case slightly differently, because in paragraph 7 of the answering affidavit at page 262, the IEC itself sets out the core complaint as it understood it. And in that paragraph, it includes the legibility of voters to vote as part of the complaint.
Yes.
Now, if that is so, somebody would be eligible to vote only if they are registered in the right ward. Am I wrong to assume that?
Justice Jeff, I'm not entirely sure which paragraph you were referring to, but
paragraph 7.
Paragraph 7, the way they put it is the core complaint of the applicants is that the Commission has not furnished a voter's roll that complies with Section 16.3 of the Electoral Act. In the result, charge the applicants. In other words, this is the accusation coming from the applicants. It has been impossible for them to verify whether the voters whose names appear, etc., are residents or that they are eligible to vote. So, yes, it is correct. The complaint was, you have not furnished a roll in relation to these 4,000 with addresses. That's the complaint. Question is that a legitimate complaint? It's only legitimate if one concludes that there has been a breach by the IEC in one or other of their obligations. That, with respect, is a very, very difficult and different case to make, particularly given the fact that we know that an explanation was furnished. I don't think a replying affidavit was even put up in the Electoral Court, if memory serves. There were only the founding and the answering. And the question was, well, what was the Electoral Court to make of that complaint and that evidence?
Was it not incumbent upon the IEC to say you don't know, you can't determine whether these voters reside in those districts? Here's information that shows they reside there. You say you don't know whether they're eligible to vote in those wards. Here's information that shows that they are eligible to vote.
Justice Jafta, if that's the conclusion that the court reaches on a fair assessment of the case that the IEC was called upon to answer, then this part of my argument will fail. My submission is that that would be an unfair reading of the case.
No, if you are incorrectly accused of wrongdoing, especially a credible body like the IEC,
yes,
to discount the potentially damaging possibility of public perception that you live in some room for unfairness during the electoral process. What you need to say, I think, is, I don't know what your problem is. I've done my spade work. I've satisfied myself that all these people who are going to vote are in the right wards. They are in the correct voting district. Here is the proof. Failure to do so seems to suggest, and I must emphasize seems to suggest that you can't vouch for the correctness of the placement of the voters. You can't tell us with confidence that everybody who will be voting is entitled to be voting in the allocated ward. And that's where the problem is.
Two submissions, Chief Justice. The first is to once again draw a distinction between the 4,000 on the one hand and the 500 on the other. In relation to the 500, that was a specific complaint, and had it been pressed before the Electoral Court, what is being put to me now would undoubtedly have called for an answer from the IEC. But the 500, which was the potentially dangerous complaint which was advanced, was simply unaccompanied by any supporting evidence whatsoever. The second answer that we would submit, and it goes back to the letter to which Justice Jafta draws my attention, concerns what it is that the IEC did when they received that complaint. And the question that we would submit has to be posed is, how does this court assess what it was that the IEC did, having received that complaint. And we would submit that the test has got to be one of reasonableness, not one of perfection. A perfect voter's roll might be aspirational, but it is simply unrealistic and probably doesn't exist anywhere in the world. What is posed by the facts of this case, then, is a different question, and that is, in the face of that complaint, this is before the IEC application to court, did the IEC take reasonable measures, yes or no? And to the extent that the applicants in the electoral court thought otherwise, we would respectfully submit that ought to have been a frontal challenge to enable the IEC to deal with it.
Do the reasonable steps taken by the IEC demonstrate that everybody will be voting in the ward in which they reside? That's the bottom line, because that's what the Act requires.
If it is being suggested to me, Chief Justice, that they would have to be satisfied of that question in relation to every one of the approximately 22,000 that I think have been identified as the numbers in the relevant wards, that would be a standard of perfection. But if they had taken reasonable measures to ensure that their voters' roll is safe, that the outcome of the election would be free and fair, then my answer must be in the affirmative. They have done what is required.
I'm sorry, Mr. Marcus. I don't want to belabor this point unduly, but here is my difficulty. If you're being accused of some dereliction of duty, such as the IEC appears to have been, to demonstrate that the criticism is unfounded or it's unreasonable or it's unfair,
yes,
you do your spade work and then come and say, we have complied because it's our responsibility to comply. And this is how we have ensured that, unlike before, nobody will be voting in the wrong or incorrect voters' district.
Yes.
Has that been done?
Well, in our respectful submission, yes, it has been done. And I again draw the distinction between what happened before the application to court and what happened in the application to court. Before the application to court, the independents had identified their cause of complaint. They had notified the IEC, and the IEC told them what they had done. That's the famous letter to which we have referred. The question was, if the independents thereafter were dissatisfied with what had been done, what was it that they were incumbent, what were they required to do? What we would submit is that they were required to come to court and to say, look, this was our complaint, this is what the IEC has done, but we're not satisfied for the following reasons, and therefore the absence of this explanation or that explanation is a prerequisite to determining this matter. But that's not what they did.
Let me ask you a different question about available. I haven't read the judgment you have referred us to, but I think I've got a fair sense of what principle you sought to extract from it. Isn't there a fundamental difference, though, between being expected to regard as available some, is it train station or something, some 100 kilometers away from where you are, as opposed to determining availability in relation to an address that was actually given to you, or an address that could take a telephone call or a visit by your people on the ground closer to where the wards are to determine whether or not people actually stay there or not. Isn't there a...
Chief Justice, I don't for one moment suggest that the facts are remotely the same. I urge the case upon you purely for an approach to the problem. The approach that the appellate division adopted was, to use their language, a realistic rather than an unrealistic one. And there is a further, perhaps linguistic argument that flows from section 16.3. It imposes an obligation upon the IEC to provide something. They have to provide a voter's roll with the addresses where available. Ordinarily, I don't suggest this is without ambiguity, but ordinarily where there is an obligation to provide something, it means that you must furnish something which you have, not something which you must still obtain.
No, that I understand. Yes. I'm confining myself to the meaning of available within the context of this case. If an address is given to you, or if an address is easily ascertainable, is that comparable to a situation where the station is 100 kilometers away? Because otherwise that case is not of much assistance insofar as we're talking about, I'm looking for the phrase again, I've got it somewhere here, realistic concept of availability, as you put it.
Yes.
I think isn't it a realistic concept of availability to say, if it's given to you, if it's easily ascertainable as opposed to a far removed station,
I accept,
then
Chief Justice,
the two are incomparable.
Yes. I accept that availability might entail, in an appropriate case, a question of degree. And in answer to your question, and I can only answer it at the level of abstraction, there may well be some cases in which, yes, it is relatively easy to ascertain a particular address, and in other cases it won't be. Sometimes it will, sometimes it won't be.
In this case, is it realistically available when you have been provided, or when you can with ease determine the address? Or is it unrealistic?
Well, I'm hesitate to answer that question on behalf of the IEC.
In making some submissions on their behalf.
But you're asking me a factual question, Chief Justice, with respect. It's a factual question, and the best I can do...
It's not factual. It's not factual.
Well,
but if it is, it's not. It doesn't relate to facts that you can't deal with, because we're talking about realistically available. And I have posed a question. Say it's given to you, the address,
yes,
or it's capable of easy verification or ascertainment. Why is it unrealistic to expect of the IEC to do that which is capable of easy achievement?
Because there's a world of difference, Chief Justice, between ascertaining, for example, one particular address or a handful of addresses on the one hand and a vast number of addresses on the other. Point number one.
4,000?
Well...
Within how long? From February?
Well, the election was looming.
From November, rather?
Well, presumably
1,000?
One has to ascertain it from the date at which the issue was pertinently drawn to their attention as a potential complaint concerning the election. And in that regard, it was a relatively short period of time. As to how it's to be done, well, it depends upon manpower resources, it depends upon electronic databases, and that's why I'm simply hesitant to answer that question at the level of fact. I don't suggest it's impossible.
Well, I heard you. Let me ask you a different question. And that relates to the scope of application of the COM decision.
Yes.
I don't know whether it applies to Tlokwe only or whether it is of nationwide application. And I'll tell you, because I need you to help me here. If we say it applies only to Tlokwe, the COM decision, what then is the position of a voter in Pofadder who say, you know, I've asked these people for the national voters roll as it applies to Pofadder. There are no addresses at all. Why are the Tlokwe people entitled to addresses and I'm not? Does it mean that person would have to bring an altogether new application for his or her situation to be clarified, or are we to understand the COM decision to apply to all other people who find themselves in the same position as those in Tlokwe?
Chief Justice, our answer is this, that by virtue of Orders 5C and D read with 6, the CAM decision has application to all local government elections. However, the question is, how do we apply that in relation to the very Tlokwe by-election, which was the subject of the matter before this court, and a new by-election about to take place in precisely the same district? That is why we suggested in our heads of argument that at least implicit in this court's order was that the IEC had to take reasonable steps to correct the defects which had given rise to the setting aside of that by-election. And again, that's a question of fact. The IEC has given evidence as to what it did. If you were to conclude that that was insufficient, then the result would probably be the same. There is this difference, however, and I think it is an important difference, and it raises a difficult issue around remedy. A critical difference between what happened in CAM and what's happened here is this. In CAM, the by-election had already taken place. And by the time the matter had got to court, the court assessed what had actually happened against 3 series of irregularities, which my learned friend has identified. This particular issue, the Tlokwe issue, is different because it comes to court in anticipation of a by-election yet to take place.
So I interrupt you. Will that by-election ever take place?
I think by the 16th of August it will. But Chief Justice, it's important because the question to be posed is a different one. In the CAM case, this court was at least able to take a retrospective look at exactly what happened. In this particular case, the Electoral Court, and indeed this court, is asked a different question. They're asked to anticipate what would happen if the election were allowed to take place and to reach a conclusion that if that were to occur, it could not be free and fair.
You see, 4,000 people want to vote, and the independents are aware of that, everybody knows. IEC is pressed initially, it does investigation and cleans up, finds people wrongly registered, people in wrong districts, and cleans all that up on your approach. And thereafter, 4,000, another company has put up about 4,000 people. The crisp and terse answer of the IEC, the addresses are not available. How would anybody know where the people are entitled to vote? So the independents go to court and say, sorry, there are 4,000 people, they've done all sorts of things, they found all sorts of wrong registrations. They say they've cleaned up, but there are 4,000 people who the IEC says their addresses are unavailable. Then comes the question that Justice Jafta pressed on you, and that the Chief Justice also pressed on you. Why is that adequate? How would the IEC be able to persuade the Electoral Court that the people are entitled to vote? And the Electoral Court says no and holds against the IEC. What is your response to that?
The response is
they have a duty to make sure the right people vote. They come back and say, we don't know what the addresses are. Why? Because they're unavailable. Why is the court wrong in holding that is inadequate?
The response is twofold, Deputy Chief Justice. And in some sense, it's a speculative one. In the first instance, the court would have to have regard to what it is that the IEC actually did. Having received a complaint from the independents, we know what they did. It's set out in their letter. That combined with what the case was, the cause of complaint which they advanced in the Electoral Court. And then the question would have to be posed, assuming that the court is dissatisfied with the explanation that was given in the letter, assuming that the court was also dissatisfied with the answers given in the answering affidavit in the electoral court, could the court reach the conclusion that this by-election would not be free and fair? If the answer to that is in the affirmative, one cannot...
IEC is a respondent and it bears the duty. It has been put to you a few times. And it wants 4,000 people to vote whose addresses are unavailable. And we know what the law is, Mr. Marcus. 16.3 tells us so. The COM judgment reaffirms and states that nobody votes unless their addresses have been properly ascertained, particularly after irregularities that the IEC tells us about. Just before the by-election, the second round of the by-elections, why is a blank, bare denial or statement, we don't know the address, is adequate to satisfy 16.3?
Because it depends upon the circumstances in which the complaint is given. I don't want to repeat my argument, but if the court is against me in relation to the case pleaded by the independents, well, then I'm afraid I can't...
Can we go...
Yes. Yes. I'm merely postulating the possibilities, that's all.
Yes. Let's go to just another area in your submissions. What in the electoral court judgment requires us to deal with historical registrations on the voters' roll? What in their judgment makes us to be seized with a decision about 16 million that sometimes is 18 million?
Yes.
Why is that before us? Sometimes 12 million.
Deputy Chief Justice, I have been careful to confine my submissions to you on the merits of the appeal. The question of the wider implications of the electoral court judgment would only arise if the appeal fails and the IEC's application for direct access is granted. Then and only then do the potentially wider implications of the electoral court judgment arise.
Moved on, I understand that.
Yeah.
I thought so your submissions are limited to that. You don't have to go there if you don't have a brief to go there.
No.
So you don't want to go there, essentially. You're not briefed to go there.
Other than to submit with respect to the court that in the event of the court reaching the question of direct access, then we would support the relief identified in prayer 6 of the IEC's notice of motion, which is the prayer dealing with the relief consequent upon direct access and the timetable which they have sought in relation to rectifying perceived defects in the voters' roll. So that might change in the light of the information which the IEC is going to present the court, but on available information we have no option but to accept the IEC say-so in that regard.
So you must have exhausted your submissions.
I have.
Thank you.
Thank you very much, Chief Justice.
Thank you, Mr. Marcus. Yes, Mr. Skakani, you're next. While you're getting ready, Mr. Skakani, which aspect or aspects do you want to focus on?
Yes, Chief Justice, I'm dealing with two broad topics. I think my learned colleagues have dealt with the aspects that on the basis of which we support the appeal. So there are two broad topics that I'm dealing with. One is linked to the debate that the court had with Mr. Marcus, which is about the meaning of where available. And I'm dealing with one aspect there, which is what we've identified in our heads of arguments in our papers as how the right to privacy is implicated. That's the first topic. The second topic that I'm going to deal with, and I think this is the topic that may have caused some controversy about some vitriol about whether or not there is a possibility of disenfranchisement, or that the CAM judgment does that, which we do not say. So
yes, featured quite prominently, I must say, and the millions.
Well, Chief Justice, I will make attempts to tone down the vitriol in that aspect, because I will locate disenfranchisement within a particular context, which is what now, in the event that this court is not with us on the appeal.
I would be interested in that, because the bottom line is council needs to help us assist the process so far as we can, so that voting does take place without violating any aspect of the law. We have a collective responsibility to do everything within our power to get to that point. So that would be very helpful.
Absolutely. Chief Justice, we have to accept right at the outset that, well, let me say there are two.
Before you go on, do you need your 10 minutes, or can we interrupt you anytime?
I deal better with the punches later when I've thrown my. I would prefer to throw my punches and then take them. If Chief Justice doesn't mind. Well, Chief Justice, can I preface the two broad positions that we're making with this submission? Our submission in respect of the appeal, in respect of what we call the error in the Electoral Court's judgment, are really about two broad propositions in that judgment. Now, I had a question to Mr. Trengov about that question, whether or not we are correct to say there are those broad propositions that the court in the Electoral Court says, well, where there are voters without addresses on the voters' roll, then they are registered in the wrong ward. If that is the broad proposition that is being made in that judgment, well, we take issue with that broad proposition, because, as I will explain later, it has consequences for quite a number of other people, because there are many reasons why there would be no address. The second proposition that we take issue with, if we are right, that we are reading it correctly, that it's a broad proposition that has implications for any voter through North who does not have an address. And if this broad proposition is correct, and this is the broad proposition that we take issue with, that the absence of an address means that the process, the registration, is flawed. If that broad proposition is what the Electoral Court meant, well, we submit that it failed to understand correctly CAM's judgment, because in our view, that is not what CAM's judgment says. So that is how I preface the two broad issues that I want to talk about. The first issue about privacy, I will not traverse what Mr. Marcus has dealt with, which is the other meaning of where available. But we accept the proposition that 16.3 is the law that compels, that obliges the IEC to ensure that their addresses were available. We have to accept that that is the law. There has been a debate about whether that happens after December 2003, or after the CAM judgment. Well, we have to make one proposition that I don't think any party can escape, is that the law is what it was since 2003. And I have no answer as to why certain things may not have happened thus far. But there are many reasons, Justices, that will result in the voters' roll not having names and sometimes no addresses. And if we accept that the broad proposition made by the Electoral Court is correct, then it has serious consequences for people who are already in the voters' roll. Now, the right of privacy, we mention it here because this court has, in a number of cases, stated its importance. Now, as an explanation of availability, let's postulate this position. Politician X, in terms of the law, must have access to my address. And I do not want my address to go beyond the point of the IEC. I do not want the honorable members to bother me. That's the first proposition. The second is there may be a number of categories, there are many categories in society who, not just because they are exercising the right to privacy, have circumstances because of their professions that would make them not wish to have their address communicated. And I'm explaining this simply to say there are many reasons why the address would not be available. Now, of course, those categories are, we've stated them. You may have people who live under witness protection programs. It could be people who work for intelligence services. It could be abused spouses, usually it's women. And it could be some judges. Those are the categories of people. It's not exhaustive. I'm just highlighting to the court that the right to privacy may be exercised by those different categories of people. But even if those people did not exercise that, it was not about their professions. We submit to this court that it must take into account in assessing why a name would be there without an address, that there may be in future and in the past voters who do not wish to have their names and addresses and other details communicated, and they want to exercise that right. So we raise that point to explain the meaning of where available. And therefore, the proposition that it is flawed when the address is there, in our view, is incorrect and has consequences that have made us refer to what we call disenfranchisement. The next point we want to make is that Section 39 of the Constitution provides that legislation, including, of course, what we're dealing with here, the Electoral Act, Section 16.3 of the Electoral Act, must be interpreted in a manner that promotes the object of the Bill of Rights. And of course, the right to privacy is highlighted by this court in the case that it did in the Investigating Directorate, Serious Offences and Others, the Hyundai matter, that where a person has the ability to decide what should be disclosed to the public and a reasonable expectation that such a decision will be respected, well, the right to privacy is implicated. So we submit, therefore, that there can be no doubt that in all this debate about whether or not the address should be there and what where available means, well, the right to privacy is implicated in this case. And this is so particular if one has regard to, I know this is not the statute that has come into effect, but we would invite the court to take account of the Protection of Personal Information Act, not because it is before the court, but because it sets out some guidelines about how we should deal with personal information. It's called POPI, popularly, and it contains an expanded definition of personal information, which includes personal addresses. We would submit, therefore, that this court has said in a number of cases, including the Hyundai one that I've said, and the NM and others versus Smith, the importance of the right to privacy. And we submit, Chief Justice and Justices of the Constitutional Court, that this aspect of the definition of where available and the possibility of people exercising that right, as well as people who just do not wish, because of their personal or professional circumstances, to disseminate their addresses, should be taken into account, because that right arises. And there would be, if it doesn't, if we ignore it, well, we would have to balance it, that limitation in terms of Section 36 of the Constitution. It would have to be limited only in accordance with that provision.
Well, we are entitled to interrupt you now, but maybe just to give you a minute or two to deal with the second one before we do.
Yes, I will try and then summarize it, Chief Justice. My parting shot on this aspect is obviously a statement that should be expected, that we're not suggesting that that right is absolute. I shouldn't be understood to be saying that. The next point, Chief Justice, is remedies. I think this question came very early. What now? Even if we're dealing with all the parties here as culprits who've caused this problem, what now? What do we do? And I think I would like to emphasize that point, because the misunderstanding about the word disenfranchisement as suggesting that it was done in CAM or it will be done here, I think is not there. This court will be, if we're wrong on the appeal, or this court is disinclined to agree with us on the appeal, on the positions that I stated earlier, well, this court has 4 options we submit. One is that for all the imperfections that the court has identified in respect of the IEC, it would have to order that the details of all the historically registered voters be obtained by the 31st of May, at least in respect of
December, or be leaving pre-December 03 out after the debate with Mr. Trengo.
I'm including pre-December, Justice Cameron, because I accept that the law operates. There may have been reasonable and maybe different interpretations about what it meant, but I think we have to accept that it starts in 2003 when the Act came into operation. But the point we're making is that, well, the second option, you would have to remove the millions of people who would fall into that category, the historically registered.
Is that before 2003 or after?
After 2003.
Oh,
yes. Well, I don't want to get into the ones before that, because that broad proposition I was talking about affects our elections since 1990.
No, that's fine. Remember, I've given you 1 or 2 minutes, so I thought you would nip it in the bud so that we can debate.
The last one, you would have to postpone the election. We submit that the 3 are unavailable, ordering the details that the IEC, at least for the purposes of the 31st of May, our deadline to proclaim for the election. That's just unavailable. It doesn't matter who we call the culprit. Because of what we've been told in the IEC's papers, how long it would take. Remove about 12.2 million voters. Well, I think it's the only reason the word disenfranchised is used, at least from our submission, is the possibility that this option itself, given the right to vote and its importance, and what this court has said in many cases, the New National Party case, the August case, this option is unavailable. The last one, postponing. Well, Section 1592 of the Constitution tells us that given the time frames that we've been told about, well, you have 90 days, and any postponement beyond 90 days would require a constitutional amendment. So that option is unavailable. The option that is available with respect is that if the court is disinclined to agree with us on the submissions we've made, that Mr. Marcus and Mr. Trengov have made on the appeal, is to suspend that obligation, no matter how it is framed, to suspend that obligation to obtain the details that the court will identify have not been obtained, for a reasonable period of time so that we do not end up with a situation that we're trying to avoid, where the election does not happen simply because there are no addresses.
Now, let's start with the privacy aspect. It will have to be, it accommodates very few people, doesn't it?
I didn't get
it. It relates to a very, very, very small number of people. For starters, I don't know of any judge who would insist on his or her address not being known.
Well, Chief Justice, then maybe if that is the case, we can cut out that profession.
Yes, because I mean, even telephones, 12 midnight, you get an SMS, there's a special at my ladies. You don't know where they got your number from. So that one is out.
Well, with respect, Chief Justice, may I just on that point, because it is a serious proposition you are putting, that you don't know of any judge who would need that privacy.
There would have to be not more than 10, if any.
I accept that.
Like Justice Lamont the other time.
Absolutely.
Yes, so that's a very minute number, and even those who are on a witness protection program, there are very few people.
I consider that.
You're not looking at 1,000 people.
Yes.
Yes, so let's put that aside, perhaps. And focus
if I may just
on
make a follow-up, CJ.
All right.
Mr. Skakane, I find some difficulty in your reliance on privacy because the IEC has not relied on privacy as a reason why details of the addresses of the voters have not been recorded.
Yes, I do recognize that, Justice Khampembe, that they may not have raised the issue. However, we think as a principle, it's an issue we would like to raise for the court to take into account of. What is important for us is not whether it has happened, is whether the principle is correct to take into account. And we would submit with respect that this principle about it is important for us, whether or not practically there are people, we could count more than 10, but the principle is important.
And now, the solution. What do you consider to be the solution? I think is what we must focus on.
Yes.
Are you saying there is a legal basis for the solution you propose, or is it the same Section 7.2 suggestion?
Section 172 suggestion.
Not of the Constitution.
Oh, yes.
That procedure set out in the Electoral Act.
Yes.
In relation to circumstances under which, in fact, the IFP proposal, in other words, is that what you are suggesting?
No. My suggestion, as I prefaced it, is in the event that the court has to find or finds that we are wrong on all the points that we've made in the challenge, and it finds that the IEC has the obligation.
Then 2020.
Yeah.
Yours is the 2020 position.
I think I would put, we have not in our papers put a date.
That's why I'm asking you.
We don't answer that question, Chief Justice, and I'll explain why. Because the IEC is the body with the obligation to handle the elections as credibly as possible. We do not know how long that would take. We have no reason to reject that because the subcommittee that COCTA that has been established to deal with because as a point of departure, one must accept that addresses are important or giving sufficient particularity for a credible election. What we are suggesting is simply that this court, if there was ever a case in which this court has to exercise its wide discretion to suspend the finding that indeed the IEC or anybody that has the obligation to do what they had to do between 2003 and now, this is the case to suspend that order because.
You see, I'm sorry, Mr. Skakane.
Yes.
I don't know much about the IEC. I was only involved in 1994 in settling some disputes in the small locality of Mafikeng when the DCJ was the deputy chair of that body. So we need help from everybody who has the opportunity to assist us so that we can understand, have a better grasp of the issues. So it doesn't help saying a reasonable period. On your own analysis of the papers before you, what is reasonable?
Chief Justice.
Because I'm disinclined to say the IEC has said it, we are bound. It doesn't work that way. It's got to be interrogated, it's got to be analyzed, it must make sense to us. That is why I say, are you able to give us your own conception of what is reasonable in the circumstances?
Chief Justice, we have no reason to disagree with the timelines put by the IEC, but I would need to take an instruction if my clients have indeed considered the question of timing. On the papers that they stand, my clients have not, except to identify that process, they acknowledge that it would be complex. But I would have to take an instruction about what they think would be the time. But as I said, there is no suggestion in our papers that we do not believe the time frames given by the IEC.
Well, Counsel, you say you want to throw your punches first before we do.
I couldn't throw any.
Well, we're not going to throw any punches. I need clarification, actually, on the remedy aspect. If on the appeal we were to hold that the appeal is bad and the electoral court, and that there was no duty on the IEC in any event to register addresses before 2003, do you agree that that segment of the argumentation would fall by the wayside? If we are persuaded by the argument that 2003 is the starting point for the obligation to record, keep, and furnish addresses, then the rest of the role would not be implicated. Do you agree with that?
Deputy Chief Justice, I mean, my understanding of your question is that, I'll phrase it this way if I'm wrong, is that will I drop my suggestion on remedy if what it meant is that the IEC must deal with the names that do not appear starting from 2003?
I'm not asking you to drop anything. Let's try again. I'm saying as a matter of law, if we were to find that the IEC's duty to record, keep, and furnish addresses started in December 2003, do you agree that it would be unnecessary to fashion a remedy in respect of the historical voters' roll?
Well, I agree with one aspect of the of what the Chief Justice has put into me, is that, well, as I said right at the outset, the law with which we concerned begins from 2003. So I would concede that that is when it begins. Now, I would still not abandon the remedy, because if you
to abandon the remedy, I want you to help us fashion a remedy. So I don't want you to abandon anything. Let's get to the next question then. So you concede that we don't have to make any declaration or decision about the period preceding December 2003.
Indeed, yes.
That's your position, and that's the minister's position.
Yes.
Very well. The second question is, do we know at all whether there are any lapses from 2003 to now? In other words, what would be the basis for the remedy? You see, we have to find an illegality to fashion a remedy. Remember, I debated this with Mr. Trengrove. So between December 2003 to now, do we know whether the IEC needs any remedy?
Well,
and so if so, why?
If the court were to find that given the fact that they had that obligation since 2003, in how they have performed that duty since 2003, they have acted in conflict with that duty. Well, the remedy that I'm suggesting, that we are proposing, arises then because you would have to deal with whether they must correct that in respect of the upcoming elections. And we submit that if the remedy were, even if the court were to find that the IEC has not performed its duties since 2003, we submit that to correct and rectify whatever the IEC may not have done right is going to take much more time for us to have a postponement or giving time to correct that in time for this upcoming election.
These papers do not deal with that. IEC tells us that they've acted lawfully as far as they know, except for certain addresses or documentation that was destroyed in certain uncomfortable episodes.
Yes.
So what would be the basis for the remedy? Remember, we're talking about remedy.
Yes.
Just want to understand what the minister's suggestions are. What do we do with the period December 2003 up to now? Unless there's evidence that shows obvious infractions.
Well, Deputy Chief Justice, I can only say this. I have no reason to suggest, well, to differ with the IEC that it has not, with its submission, that it has not acted unlawfully since 2003. My only proposal is that to the effect that the court does not agree with them, to the effect that to the extent that the court finds that with all the explanations with which we do not differ, because we are in no position to know what they have or have not done, at least not to that detail. If this court were to differ with the IEC on whether it has acted lawfully since 2003, that is the point at which the remedy we propose arises.
Mr. Skakan, I'm sorry. One of the remedies that you propose is that the court should suspend the duty imposed by Section 16, sub 3,
yes,
for a fixed period. What would be the basis of that in a situation where we don't declare the section to be inconsistent with the Constitution? Do we have the competence as a court to suspend the operation of an act of parliament that is already in effect?
Well, we submit in our heads of arguments, Justice Jafta, that because of the effect it would have, this is one of those cases that in our submission fits in with what this court discussed in War School MLO, in which you give yourselves as the court a wide discretion to suspend an order of invalidity of action or a statute.
That's a different scenario.
Yes, I accept.
You would have a declaration of invalidity.
Yes.
And Section 172(1)(b) then gives the court a wider remedial power to suspend that declaration of invalidity to allow the law to operate whilst the suspension continues. But here it is different. You are asking us to say, Parliament, even though this piece of legislation that you have passed is consistent with the Constitution. There's nothing wrong with it because the IEC, which was required to have taken certain steps, did not do that. And the consequences now would be that 12 million people would be disenfranchised. Therefore, we, the court, we suspend the law that Parliament has put into operation. What would be the basis of that?
Well, I can put it no higher than this, Justice Jafta, is that we suggest, in our view, that for the point that you've mentioned of the consequences of what would happen if you were to remove the names of voters because either they remain there unlawfully because something was not done by the IEC, we suggest that this is the case in which, in our view, a just and equitable order would be the order that allows the elections to take place, at least for purposes of the August 3, as has been suggested.
Lastly, the emphasis has been, from the minister's submission, has been on permitting everybody who is entitled to vote. An order that the court has to issue should not deny people who are entitled to vote. But isn't the other side of the same coin is that people who are not eligible to vote in certain wards should not be allowed to vote because they interfere with that exercise of the right to vote by those who are eligible to vote.
Well, maybe this is my answer to Justice Jafta about that, is that in these papers, I accept that in the Ham case and in the Electoral Court case, you were dealing with specific allegations of irregularities. It is my submission that for purposes of the upcoming election, no case is made or suggestion is made that there is a real possibility that the names that are not there would constitute fraud or an irregularity. There is no case made on the papers to suggest that.
Well, remedy again, Mr. Skakani. You know, the rule of law applies to all of us, even the judges or the courts.
Yes.
We can't exercise power that we don't have.
Yes.
Where do we get the power from to ignore the law that governs a particular situation? Because we are not the law unto ourselves. So which law allow us to suspend?
I am not suggesting that the court is above the law. If I was understood.
That was just a preface. I'm not attributing that statement to you. The real question to you is which law allows us to order the disregard of the natural legal consequences of Section 16.3.
Well, I would submit, Chief Justice, that Section 1721B of the Constitution confers what I would say are wide remedial powers on this court to adjudicate a matter of this nature and take into account what would happen if it did not suspend or condone the illegality that either has occurred or continues to occur.
And we suspend the operation of any act of parliament that has not been declared constitutionally invalid? Do we have that power?
No, you don't.
So in terms of which law then are we empowered to do what you say we must do?
I'm simply suggesting that, I'm simply submitting, Chief Justice, that given our suggestions about the consequences.
Consequences I appreciate. And nobody wants to find himself to be party to an outcome that says, millions will not vote.
Yes.
No. But how do we get there? It must be a legally sanctioned process.
I can put it no further than what in my submission, are the discretion, the remedial powers in Section 172. I have
should we remedy here? What is admitted as wrong? In your debate, the Chief Justice, the one thing that popped up was, what should we remedy? The one is, do we have the power? And the answer might be no. But assume the power is yes. What is the wrong here that calls for a remedy? The IEC does not admit that it did not do its function from December 2003. We don't have evidence that there are people whose addresses they don't have, which they should have, except where one, they are not available, or two, which is lawful, or two, those that were destroyed. So what must we remedy? What is the gap here?
Well,
what is the malady that ought to be remedied?
Well, Deputy Chief Justice, I prefaced my submissions with the statement that I make these submissions in the event that the court finds that the points made by Mr. Trengov explaining what the IEC says it has done up to so far. So I assume that that is correct, but I've made my submissions on the basis that this court may well not agree with Mr. Trengov on that part, and that is the basis of the submissions that I've made.
Well, Mr. Skakani, let's go to Section 172, on the strength of which you say we may make the order you propose, and show me which part of Section 172 of the Constitution empowers us to suspend the operation of the law in the manner you propose. Just read it out.
Well, Chief Justice, I will refer to 172B.
172 1B. No, you mustn't start there. Start from 1.
Yes.
So that it can be properly contextualized.
I'm there. Do you want me to read 1? Well, 1 says when deciding a constitutional matter within its powers, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And B, may make an order that is, that is just and equitable, including 1, an order limiting the retrospective effect of the declaration of invalidity. 2, Roman figure 2, that is, an order suspending the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect.
So you're going to be relying on Section 172 1B.
Yes.
Now, which invalidity are we tying up the suspension to?
Well, I'm tying it up to a possibility that this court finds that there has been conduct on the part of the IEC. Conduct, as mentioned in...
Which is constitutionally invalid?
Yes, that they have not acted in a manner that they are expected by the Constitution and the relevant statute to act.
Which part of the Constitution says they must do what they haven't done?
I don't get that, Chief Justice.
Oh, if you say they have not acted in keeping or in line with a particular constitutional provision,
yes.
Which one is that?
Well,
that renders their conduct constitutionally invalid.
Well, first of all, it's not my submission, Chief Justice, that they've done so.
Just said that. Anyway, explain yourself. Let me not put words into your mouth.
It's not my suggestion that they've done so. I've premised these submissions on the basis that the court is not in agreement with them. And we would like the court to fashion an order that is just and equitable. And in our view, it would be just and equitable if that order does not postpone the election, does not remove the names of people for different reasons, are
Mr.
already.
Skakani, it's out of no disrespect that I interrupt you. Please allow me to interrupt you. You seek to rely on Section 172(1)(b) of the Constitution.
Yes.
Now, that section makes reference or presupposes a declaration of invalidity. Within the context of this case, what is it that that amounts to some constitutional invalidity that would allow us to act in terms of that part of 172?
Well, I concede, Chief Justice, that there may be no constitutional invalidity we are dealing with.
So you appreciate our difficulty?
I do. I think on that point, I do appreciate that,
yes,
that distinction.
I'm sure some of your other colleagues will help us. At the end of the day, we must find a solution, but you people must assist us.
Absolutely.
Yes.
Well, the last point, Chief Justice, relates to the proposals that have been made by different parties to assist this court. And one does not criticize them because they do not come from a good place. Our only point about them is that first, while we appreciate that they're an attempt to assist the court, we make this submission that
each ones, you know, it's like we are speaking in parables now. Mention them.
Well, the DA suggestion, I will take the Chief Justice to each one of them, but the point I wanted to make the point about what they all imply, because in our respectful submission, they entail in different ways creating or tagging, but creating a separate role in our submission. So,
now we'll interrogate their submissions in due course.
We submit that if one accepts that Section 1D of the Constitution talks about one common national voters' roll, the suggestion that strays from that provision, in our view, is unlawful. And our submission is that there would be more problems if you created a separate roll, whether you call it a provisional roll or you have a certified or uncertified list. In our view, all of these suggestions create a list, a separate roll, and we submit that it would be unlawful to do so. Those are our submissions about the proposal.
Thank you very much, Mr. Skakani.
Thank you, Chief Justice.
Mr. Tokota told me that he doesn't need more than 10 minutes. Mr. Tokota, you'll be the last before we break for lunch. I assume you all agreed on a 30 minutes lunch? Yes, if I had it my way, we wouldn't even eat.
Thank you, Chief Justice.
Which issue are you going to deal with, or issues?
Actually, Chief Justice, I said to you in chambers there that...
I beg your pardon?
I said to you there that we have agreed, the colleagues, Mr. Femtang and Marcus and all of them, we agree in general terms. So there is no need for me to repeat what they have to say.
Sure. So it is on that reasonable approach that you highlighted much earlier that I want to know if there is a particular point or points you want to highlight, and if so, what are those points or what is that point?
No, 5 minutes is enough for me to say what I have to say.
To make which, I'm sorry, Mr. Tokot, just so that we can anticipate your submissions properly. 5 minutes to make which point?
The point I want
to emphasize which point?
Is to emphasize the interpretation of the Khams order. And then the distinction between the 2003 and period prior to that.
That one you can, I think, assume that we move from 2003. We haven't decided, but move from that assumption based on how the argument has panned out.
All I have to say about the Khams decision is that it should be, that prospective approach should be, the order should be interpreted in such a manner that the order didn't require the IEC to go back to 2003 and investigate whether those people in the voters' roll where it had in fact all the addresses. It must be interpreted on the assumption, unless there's a contrary view, that since 2003, the voters' roll contained the addresses where those addresses are available. So that the requirement for the registration of aspirant voters with addresses to be also included in the voters' roll should be interpreted after the ConCourt's judgment. Then there will be no problem of suspension of anything. So in other words, all what the court has to say, no, ConCourt's judgment didn't require the IEC to go back and investigate and furnish with all those voters' roll from 2003 to date or after the ConCourt's whatever, that all those the voters' roll has got the addresses of everyone where it is available.
No, Mr. Tlokwe. What does section 16 subsection 3
yes, sections
expect of the IEC to have done since 2003? That is the question.
Yes.
Harm or no harm? What does the act... I'm sorry, Mr. Tlokwe. What does the Act of Parliament require of the IEC to have done? The law itself.
Yeah. Chief Justice, the IEC was expected since 2003 to have the addresses where available on the voters' roll, harm or no harm.
Yes, and if there are addresses that could be or could have been easily ascertained, and yet the IEC did not ascertain them, what should we do? That should be the question. Help us to resolve that issue.
That question would only arise if there's a complaint. That's why I say the court should move on the assumption that the IEC complied with its duty to have those addresses on the voters' roll where such addresses are available.
Can on the understanding that the 5 minutes is up.
Yes.
Thank you very much, Mr. Tlokwe.
Chief Justice said,
okay.
Yes, please. Yes. I know the Chief Justice said, let's proceed on the assumption that we are looking at post-December 2003. I am actually interested in pre-December 2003. And in your preface, you indicated that you actually wanted to argue that. You probably recall the question that I raised with Mr. Trengove, which is that based on section 190, subsection 1B of the Constitution, there may well have been an obligation on the IEC even pre-December 2003. What submissions would you make in that regard?
Firstly, Justice Madlanga, I accept that there was even pre-December 2003 an obligation on the IEC to register an aspirant voter to have the address of the place in which the voter is to exercise his right to vote.
Thank you.
Thank you. Thank you.
Thank you very much, Mr. Tlokwe. The court will adjourn until a little after 20 past 3 according to that watch. That will be 30 minutes. Court adjourns.
All right, good afternoon. You've been watching live visuals from the Constitutional Court, where the IEC is, of course, applying in the matter regarding the addresses of the people that are going to be voting. We're going to take a quick ad break. We will be going back to court in about 25 minutes or so, but we will be back on top of the hour with the bulletin. Do stay with us.
Defied family and traditions to follow her dream.
Decided that I'm going to prove to them that they were wrong.
The first breakthrough came in when she was studying and touring in Europe.
That was my first breakthrough.
Generations was her first television debut in South Africa.
It was my first gig. I was very excited. I was very happy. I said, yeah, this is confirmation I'm at the right place.
After pain, rejection, and suffering, her dream became a reality.
I followed my path, and I'm happy and grateful and blessed.
Join your host, Puleng Mulabati, on Rupilong every Friday at 17:30. Even though people didn't know about Zika virus until now, this disease was discovered in Uganda in 1947 and was isolated from human in Nigeria in 1968. In 2015, there was a massive outbreak in Brazil affecting more than 1 million people. Even though Brazil had fewer than 150 cases of microcephaly in the whole of 2014, more than 4,700 cases have been reported since 22nd October 2015. Of these, 404 have been confirmed and 3,670 are still being investigated.
I am now declaring that the recent cluster of microcephaly and other neurological abnormalities reported in Latin America, following a similar cluster of French Polynesia in 2014, constitutes a public health emergency of international concern. As a precautionary measure, and because of the association, a coordinated international response is needed to improve surveillance, the detection of infections, congenital malformations, the detection of neurological complications, to intensify the control of mosquito populations, and to expedite the development of diagnostic tests and vaccines to protect people at risk.
Declaring Zika as a public health emergency of international concern singles the disease out as a serious global threat. It puts it in the same category of importance as Ebola. Unlike Ebola, where the focus was on boots on the ground, with Zika the attention will be on understanding the link with microcephaly. The WHO will coordinate countries' health agencies to conduct trials to determine the risk. It will also encourage efforts to stop mosquito that spreads the disease, as well as finding a treatment or a vaccine to stop the virus. Meanwhile, South Africa appears to be gripped by another infectious disease, typhoid. Several cases of this disease have been reported across various parts of the country, including Gauteng. The disease is transmitted from one person to another through drinking water or food. Typhoid is reported to be an infectious disease that has fever-like symptoms and can damage the digestive system severely. The Western Cape Department of Health in the last week confirmed 3 more cases of typhoid in the province. In the Gauteng province this year, 7 cases have been reported of typhoid, resulting in 1 death of a Malawian woman.
We are positive that the situation is under control. What we need to put an emphasis on is education on hygiene. We need to make sure that we wash hands, wash, food that we are preparing. And even when we are about to prepare food, let's not forget to wash hands. When we go into a bathroom, same thing. After we just wash our hands, make sure that we don't have any contamination, because this typhoid emanates from the contamination of water, contamination of...
But no! Statistics released by the Laboratory Services in South Africa shows that in 2015, there were 72 cases of typhoid and 103 in 2014. Typhoid is said to be a preventable and treatable condition.